Good afternoon, everybody. Call this meeting to order of the Town of Barnstable Board of Health for Tuesday, February 28th. Roll call, please.
Yes, Tom Lee.
Yes.
Dr. Guadagnoli.
Present.
Dr. Leskow.
Present.
Dr. Kiana.
Here.
John Norman.
Here.
And Dr. Waller. I got everybody. Thank you.
Yep, we have quorum. The first item on the agenda is just a presentation by Town Attorney Charlie McLaughlin, Senior Attorney, to speak on the delinquency of sewer connections. We just talked to him. He'll be here momentarily, but the background of this is mostly informational for board members. We've been asking questions about people that have, specifically the Stewart's Creek project, who have still not hooked up. There's a certain percentage of them that the houses are empty, the water's turned off, the property's in probate or whatever. That's understandable. There's a few that still just haven't hooked up. So we've asked the question, and especially with the future of sewering in Barnstable, the 3 different phases, the thousands of homes that are going to be eligible to hook up, you know, what are our powers, what are our abilities, what are our, you know, unfortunately, recourse for property owners that just refuse to hook up or for whatever reason. And we just want a clarification so that we could develop a policy that's consistent and well understood by the general public. But not seeing, yep, here he is, just as he walks in. Mr. McLaughlin, you have the floor.
Such thing as sneaking in the back. Sorry about that, folks. We had a conference call that was going longer than planned, as always. So, the question, Attorney Charles McLaughlin for the town, just for the record, the question that's been presented to me is with respect to sewer hookups that are not yet complete and the grace time that had been provided back when this was an important local issue for the neighborhood, that the grace period has expired. And Tom was good enough to give us compliance. It's actually boiled down to a fairly small problem at this point. I think there are 13 properties yet to hook up. I'm unclear exactly where they are in the grace period, whether the grace period on some or all of them has expired, but it's only 13%. We've got over 92% compliance now in Stewart's Creek, so it's a problem that is resolving. And this is certainly an important conversation, I think, for the longer term. And basically, our remedy, if you have a property owner that is simply non-compliant and refuses to abide by an order issued by this board, is to go forward with usually a Superior Court action seeking a court order to do the connection. And obviously that's an extreme measure that we hope we wouldn't have to resort to. But that said, the court does have, and it's also Superior Court, but also Housing Court in some circumstances can step into that debate and issue appropriate orders. And frankly, I think both courts, particularly Housing Court, is well suited to do right by the property owners and getting them to comply and finding out how best we could help them. To that end, I think what I would like to suggest is that we take a look with staff at the outstanding properties and tailor a letter generally for the 13 property owners involved and identify for them and certainly provide names and phone numbers for information on how, if finances are an issue, they can in fact be assisted in that regard. We've got 2 definite routes. One is the county route for sewer and their loan program, but also in the recently adopted sewer regulations that we put into place late last summer, early in the fall. Forgive me on the timeline, but in any event, fairly recently, the town now has the ability to actually, at the request of the owner, either have the property owner do the work, the town would pay for it, and then bill it back over an extended period of time on the tax bill. And it would be a betterment lien, if you will, that would need to be paid on a regular basis, and it would be some nominal rate of interest. But we can get into that in more detail. The point is that is a really important element of what we're all facing with CWMP in the near future, and we're going to have a full regimen of information available to property owners who might want to take that route. That's also obviously available forward-looking on the CWMP for the cost of sewers going down the street, but we recognize that the cost of the actual hookup from the sewer to the home is the property owner's responsibility. How they pay for it is where we might be able to lend a hand, so that with that, there should be, I would assume, unless you have a completely uncooperative property owner, there are ways to get this resolved and get it resolved fairly quickly and painlessly, spread out over every one of these costs, depending on where it's going into the house, through the side yard, backyard, front yard, how far it is from the street. Every one of these are going to have costs that differ from one another, but in the scheme of things, spread out over, with the town program, over, say, a 20-year period, the annual bite is, the cost of a dinner someplace. So we recognize it's a problem for some folks, and we hope we can provide some assistance on it. So what I would like to suggest in specifics with regard to the 13 property owners left is that we I'll work with staff, and I presume it should go out on our stationery at legal to indicate the seriousness of our intentions, but to invite them to contact staff, and we'll do everything we can to help them move forward. We would be asking them, if they're out of compliance, to provide on a fairly short timeline, which I would need your guidance on, but I'd suggest maybe 60 days to produce a contract with a qualified installer and a date by which that work is proposed to be completed, and leave it to staff to sort through that. And if it's not sufficiently explained why it can't be done in that period of time, then the property owner could come back to you folks for further guidance. And if there is not compliance, either you don't get the contract, or they're looking for an unreasonable time to extend, I think it needs to come back to you for one last look-see in a hearing, and then on failure to agree for a very short timeline at that point, then we should have a protocol in place to consider starting legal action and seeking injunctive relief. I'm not directly here to speak to what we've been talking about and what the manager's been talking about for quite some time in terms of the new regs and the Board of Health critical involvement in connection orders and so forth. But I would like to suggest respectfully that we perhaps have an open session with all of the players involved to sit down in a public session and get that protocol established on your vote, and we can then publish it and get the word out that it's coming. And I'm told by DPW, I gather it's sometime in the next this fall coming, that you'll start seeing orders for inspection and installation along Finney's Lane and all of that work. So it's on the threshold now. We do need to get that notice out. I know from our perspective, we'll certainly have staff available to, from finance and from DPW, et cetera, to answer any questions that you might have. I think the one-off nature of only 13 left at Stewart's Creek, we can work through that. There was a lot of grace issued at the time to the owners because of new installations and so forth. We'll have to handle those. I think that time is just about expired if it hasn't, and that's 18 years to get the job done. So I don't think have been at all unreasonable, and I think we really do need to be polite but firm as to when this needs to be done. I'll need your guidance on that, and then we can reflect that in a letter to them. And then looking forward, we can have a hearing on the new hookup orders under CWMP and what your policy is going to be, and get that resolved and get it published. So happy to answer any questions that you may have.
Great, thank you for that, Charlie. Could you also expand just a little bit on, we kind of went from, show cause hearing to legal action. Is there, fines? Is there, small stuff that the board has as far as within our powers to be able to issue to, maybe give a little bit of a nudge before we actually, go for injunctive relief or anything like that?
I think you can certainly leave the door open for an opportunity for a property owner to come in if they wish and have that specific discussion on what their circumstances are and find out why there's noncompliance. All I'm suggesting, I think, is to get this ball moving, that we have a fairly tight timeline for them to either produce a signed contract or come back to the board for a discussion. But what you do on Stewart's, again, I think the prior boards, plural, have been very understanding. We now all know and recognize that we probably wouldn't have been as gracious in extending 18 years ago, given what damage is being done by the nitrogen release that we now are acutely aware of. So it's hard to tell somebody in the CWMP context on Finney's Lane or someplace else that is looking for an extended, no, you got to do it in 6 months, but, well, what did you do for Stewart's Creek after 18 years? So I think you do have that opportunity for fines. We've found that if someone is in whether it's a zoning violation or building code violations or even some of the other areas where we have an extensive opportunity for fines, you'll know very quickly whether someone's serious about it or not. And a lot of them, some of the serial violators, the fine structure is completely unrealistic in today's atmosphere, and you find out very quickly that a lot of them assume it's just a cost of doing business. And when we have overcrowding situations, et cetera, and those who are out there who want to play the game know very well how to play it, and therefore we're resorting more and more to hearings at the housing court, which is really outstanding in terms of having staff in place who understand what the issues are and being able to work with people if there's a genuine hardship. But in terms of where we go with this, I think you'd be well within your rights to consider what pitch is made for further extension. But the room for any further extensions would seem to be pretty narrow at this point. I would suggest, because again, the folks who are on the back end of this have had 18 years to do it, so it's almost time to replace the system. So,
yeah, I mean, speaking for myself, I think this board has been extremely, generous with people that have come in and just tell us, it's a show cause hearing. So show us the cause. Why do you, why is this delay? Some had very legitimate reasons. The house is stuck in probate. Nobody's living there. The water's turned off. Okay, fine. They're not adding any nitrogen. Their discharge is zero. That's fine. And then, but we've had the other end of the spectrum where people didn't even show up for the show cause hearing. They didn't care. They were like, nope, I'm not coming. Got no answer. And it's like, okay, we're dealing with a neighborhood right now, but 5 years from now, we're going to be dealing with, villages with hundreds of homes that, have got to hook
We
up.
just
and we
just
want-
completed the first phase of the takings for private roads, and I think we had on about 8 or 9 private roads, 300 houses. So this tidal wave is coming, and we don't have a lot of luxury to handle it other than in a blanket fashion. And obviously, if there is extreme hardship, you're more than entitled to understand that. It's just, I'm not. We'll certainly be guided by your direction on it, but I do ask in terms of enforceability. It makes it more and more difficult to get good compliance the more exceptions that are granted. So,
Great.
thank you.
Any members of the board with any questions?
Just a question.
Sure, go ahead.
For us, actually. And thank you very much.
Good to see you, Doctor.
The person who was here either last month or the month before, clearly it was a huge financial issue. Was that Stewart's Creek? It was, okay. All right. So just knowing that there is an ability to help somebody is really, I think, what we were struggling for was
Yeah.
what direction do we point somebody in who
Yeah.
clearly is just
Yeah,
in
you-
financial distress.
You assume that it's been out there for so long that they have all the information, but one of the persons here was truly like,
Yep.
it was informative when we said to them, well, there's a loan program with the county, there's options.
Absolutely, yeah.
And we
Yeah.
got them connected with them, and they're moving forward now, and it's,
That would be
that's-
one of the, and the manager's been clear, we want to continue to work. So the letter that I contemplate drafting, and frankly, I'd like to share with you and with Tom, and the board for that matter, without violating open meeting law issues, but that being the focal point, there is assistance available. It's simply apply for it. We, to the extent that it will still be the property owner's obligation to contract for the work, we can assist with paying for it. We'll just keep our weather eye out for any gouging, which is something I'm going to be very worried about. We're all going to be worried about because there's only so much bandwidth for these, not only just Barnstable, but when you start looking at the impending DEP regs countywide, we got a massive problem in our hands, and
Yeah,
they're going to be out
logistics
there.
for pipe and
people out
materials
there
alone.
gouging them, and I don't want to be a party to the gouging by financing it. So, we've got to be mindful of that.
Yeah, I mean, that was my goal as chair, is to just present to the members of the board options and say,
Right. Yeah.
moving forward, this is how we dealt with Stewart's Creek. This is, there's a slight model in place, but we probably need to modify it because, as you said, that was extremely generous. And the pro forma, the financial end of it falls apart pretty quickly if we give that much time for such a vast amount of people that
Well-
have to hook up to sewer. So we want to be, cognizant of that, but I want the board members to have information moving forward to say, here's how we're going to deal with the notifications, the timeline, people that just put a brand-new septic system in 3 years, we're going to give them a little bit more time than someone that has a 10-year-old system and someone who has a 15-year-old system, and, those type of things to say, that there's a certain amount of, public outcry that is the genesis behind this, and elected officials, this is what they put in place based on their being elected, and that's the representative of the people. So there's a certain respect to that we also have, and I want to make sure that we move forward with their plans and not be a hindrance to it, but we also want to be able to be that guiding, spiriting to getting these things hooked up as quickly as possible and as painful
And
as
as
possible.
relevant as the town's finances are, probably the more driving force on this is that DPW is telling us weekly that if we don't get good compliance, we will fail on our compliance obligations for nitrogen loading in the bays, and we won't be able to achieve it. And then we're already in litigation with Conservation Law Foundation, and that type of failure that's avoidable because we have been perhaps overly generous will come back to haunt us with federal court orders, et cetera. So it's just the reality of doing this massive project. But we will make sure we cover those options in the letter. I'd welcome any input from anyone. in the letter to make sure that we've expressed what your will is, but get this letter out well before your next meeting.
Yeah, and
So-
I know Tom Lee has been working closely with DPW. I've
Yep.
been available to answer questions and go through stuff and come up with, plans. But that's, I'd like some sort of boilerplate
Absolutely,
put together where town managers,
Yep.
finance, legal, Board of Health, Health Department,
Yep.
DPW, we're all like, this is the game plan going forward. This is how we're going to, get people to hook up as quickly as possible, and this is how we're going to deal with those that are, dragging their feet. But so, that's, the goal for this was informative and to start the ball and start the conversation.
There is, there are more radical positions you can take, whether or not if you got a failing system and no one hooks up or no one corrects it, whether or not the property is habitable. I don't think, except in an egregiously extreme case, that you'd use that option, but I was asked to provide options. I don't recommend that. I think the courts are well-suited, and with our staff now regularly taking cases into court without our office having to be there for all aspects of it, only if it doesn't resolve and it is contested, we've got to go in. But I think the opportunity for having that type of discussion with folks and working with them is present, and that's the route we should take. So,
Great.
Good.
Any other questions, Tom, Lee?
Just for your information.
Sure.
The DPW is preparing an information package
yes,
for the homeowners.
yes.
So I have asked them if there is a package available for us to look at, send us a copy so that the board member have a basic
Absolutely.
understanding
Yep.
of what is the
Yep.
information available for the homeowner.
And as we're speaking with regard to the sewer ordinance that we passed last fall with the council, as something that complex, there are some tweaks we need to do to it. We've been spending a lot of time on cleaning that up, and certainly we'll keep that in mind. But finance can certainly play a role in helping through planning or otherwise, and DPW to work the finances as far as the town side. So, but I want to reference that in our letter so that we're not just throwing them an anchor as they're swimming. So,
Any other board members' questions?
Question, Mr. Chairman?
Sure, go ahead.
Not a question, but Charlie, if you're interested, at the end of the agenda, number 10, we have a couple of items to discuss. You're invited if you want to, if you have any comments on those two items. One is temporary holding tanks in between when sewer is coming to the property within 2 or 3 years. Instead of putting a whole new septic system in, we want to give another option.
sure.
And the second item is the connection deadline policy that was discussed and proposed. If you have any comments on that, the 6-month policy, or if you have any comments on that now. Is it too premature to have on the agenda now, based on what you just told us?
I think from the discussions I've had at staff levels that it would be more productive in terms of policy assistance, development assistance, to schedule a meeting, perhaps a one-off meeting, and give everybody time to come in and talk about it, including staff. I've had minimal experience when I last dealt with holding tanks. There was some litigation over in Long Beach area, and they weren't even allowed at that point, so it would have been an obvious answer for that particular case. But so I think I'll let the experts keep the lawyers out of the sewer business. But we're close enough to it anyway, so thank you.
Yeah, I wanted that, the proposed policy deadline to connect sewer, I wanted to put on the agenda.
Sure.
And we're going to just keep continuing it so that it doesn't get,
I think
lost
from, yeah,
in the shuffle, so.
Oh, absolutely, and I
Yeah.
think I'll take, maybe you can do the same, we'll have a discussion with management and get this on and
Perfect.
in a way that makes some sense and gives everyone time to consider it. So,
Great. Thank you so much.
thank you all.
Thank you, Charlie.
The next item up on the agenda is, this is a regulations policy change, proposed change in the Town of Barnstable Code, Section 322-5, outdoor dining regulation. This was a proposal that was brought up mentioned by Dr. Guadagnoli at one of the previous meetings, that some of the policies that the board had enacted during COVID to help with outdoor dining, some of them felt like even, we could continue them and keep it and make it part of our policy, not just temporary. So we asked Tom to put together a list of those items that as a health department they thought were reasonable, and we put those out there. We read through them last month at our meeting, put it out there to the public to review. And Tom, if you want to just maybe give any input on it, if you've heard from any of the business owners or anything, I'm happy to continue it another month if you think there's more public input. If not, I'm happy to entertain a motion to adopt.
It's been quiet, excuse me. All the restaurants were emailed the draft proposal. It's been very quiet. Haven't received any phone calls myself. The board seemed very positive about it at our last meeting. It takes away some requirements. It makes it easier for restaurants to provide outside dining, and that may be why we're not hearing any comments.
Okay.
It'll help the businesses.
This is a public hearing. If there's anyone from the public that wanted to speak onto any of these items to change, they can come forward. Seeing none, we'll close the public hearing on that. What's the board's thoughts? You want to?
I would think that with no replies or anything, that, and we've been through this now, this is the second time, and the things are all seemed very well done, so I would be in favor of approving it.
All right, let's, I would entertain a motion to approve.
So moved.
I have a motion and a second to approve the proposed change in Town of Barnstable Code Section 322-5 for outdoor dining regulations. A roll call, please.
Yes.
Dr. Guadagnoli? Yes. Dr. Canna?
Yes.
Dr. Leskow?
Yes.
And John Norman?
Yes. That's unanimous, thank you.
Unanimous? Thank you.
Next item on the agenda, this is a show cause hearing, food grease trap, John Green Duck Inn Pub, 447 Main Street, Hyannis, map parcel 308-081-001. Grease trap has not been pumped and is not accessible. Is anyone here from the Duck Inn Pub or John Green? Come on forward. Just make sure the green light is bright on the mic.
I'm John Green from the Duck Inn Pub, but to better answer your question on this is the property owner, because he's responsible for the grease trap, and so instead of me assuming things, I'd rather have him answer your question.
I think from the letter we got, this was taken care of, and the one request from DPW was just to make sure they brought the cover to grade. And
I brought the picture
yeah.
of the patio.
because of the brick, so, I mean, I don't think there's an overwhelming need here to browbeat this. You came in compliance, it's just the one issue is to remove the bricks, bring the cover up to grade, and then do the bricks around it so that the cover is accessible. If that's amenable to you, then we can just
That's
move on from this, and thank you
take care of
for
that.
applying for it. So, Tom, you want to have staff just go out and check it maybe in 30 days? 30 days, we'll just check, and if for some reason it's not brought up to grade, then we'll bring it back in again.
Okay, all right.
Okay? Thank you so much.
Can I just ask you to put your names on the list here? Thank you.
The sign-in sheet. Okay, the next item on the agenda, this is show cause hearings for tobacco 1 violation. So, looking at the 20 or so violations, and let's say we give every single person 5 minutes to speak on this, we're going to be at this for an hour, which is not really my druthers. So what I'd like to do is just get a presentation from Tobacco Control and basically talk about what you did, how you violations, and then maybe the people on this list that are just, this is their first violation, 1 violation, we would just kind of do a mass warning and send out, and then the ones that had 2 violations in a short period of time, we would want to hear from you and kind of put you a little more under the spotlight.
Okay, thank you, Mr. Chairman. I don't blame you. It could take forever, right? So, Bob Collette, Director, Cape Cod Regional Tobacco Control Program from Barnstable County Department of Health and Environment. As you know, each year we go out and we check every retailer in each town within our program, which is constituted of 23 towns, and Barnstable being the largest. And so on January 9th of this year, we set about our yearly duty of taking an underage person around town to attempt to purchase a tobacco product in every retailer. On this occasion, we were able to purchase 19 separate tobacco products at 19 retailers. The majority of which you'll notice if you've read the reports are single cigars or packages of cigarillos, which are very popular among the young people. Otherwise, if the retailer didn't sell those types of products, he asked for cigarettes and in some cases was able to get those as well. So an 18-year-old youth, male, who was working with me that day. And it's important to note that this is by far the most sales I've ever had in any municipality within the 28 years that I've been doing this work.
Okay, great. Thank you for that. So with the board's approval, what I'd like to do is just kind of talk to, basically, I'm going to just read off the list of those that had one violation, and that's it. And then I'd like to address you and have members of the board address you also as to the importance of maintaining your license and keeping and checking for IDs and obeying the law. In that, people make mistakes. We all have had employees that don't do what they're told. We understand, but again, I don't want to just have one after another come up and basically tell me the same story, or, because we'll be here for hours, and I don't think anybody wants to do that. You've got lives, you got to want to get back to work. So I'd like to address, basically, I'm going to read off the list of the ones that had the single violation and deal with those individually. These are the places that had a single violation on this day. Barnstable Bottle Shop, 10 Seaboard Road, Hyannis. Cape Mart, 130 Center Street, Hyannis. Centerville Food Shop, 1620, also known as 1638, Falmouth Road, Centerville. Cumberland Farms, number 2348, 1165, also known as 1171, Iona Road, Hyannis. Luke's Liquors of Route 132, 1166, Iona Road, Hyannis. Luke's Super Liquor, 395 Barnstable Road, Hyannis. Mid-Cape Garage Center Incorporated Mobile Mart, 2145 Iona Road, West Barnstable. The mobile station, J&J Auto, 381 Camp Street, Hyannis. Osterville General Store, 16 West Bay Road, Osterville. Sam's Food, Situate Gulf, 4738 Falmouth Road, Catuit. Speedway number 2429, that's at 149 North Street, Hyannis. Speedway 2442 store number, 156 Iona Road, Hyannis. Tobacco Master, 606 Main Street, Hyannis. United Gas, 199 Falmouth Road, Hyannis. Willow Package Store, 696-700 Yarmouth Road, Hyannis. And Willow Tree Markets, 15 Charles Street, Hyannis. To those individuals, and I'm going to let other members of the board speak their minds on this, we do take this very seriously. I don't want you to think because we're trying to expedite the meeting that we're just poo-pooing this in any manner whatsoever. Those of you that have had a single violation, I would forewarn you, don't have a second violation, because we keep track of this, and if it comes back before us at their next sting operation, at their next violation, we would be, less likely to be as forgiving. One violation, we understand everyone makes mistakes. Two violations, that's not proper training of your staff, that's not obeying the law, and we could look at fines or suspending or revoking your tobacco sales license. Any members of the board that would like to speak on this item?
What I'm reading here is, according to Mass General Laws, Chapter 270, Section 6, excuse me, any proprietor or other persons who fail to comply with these regulations shall be subject to the fining structure set forth in Mass Tobacco Law. Within a 36-month period, the first offense is a $1,000 fine. So that would be, they would all be given a $1,000 fine?
They're subject to it. We've had this discussion before. Go ahead,
If I
Bob.
may, yes, Mr. Chair,
That's
thank
the
you.
law.
Yes, the board is compelled to apply that fine under Mass General Law for a first offense per each violator. it's, it's reflective of the serious nature which the state takes with tobacco sales. So last time around, I think we went through this, and there were a few that, that the board fined under the new law, which isn't so new anymore. It's 3 years, plus at this point. So yeah, the board is actually legally compelled to issue those fines.
If the board is compelled to issue the fines, then there's no real point in bringing it to the board.
Well,
If the board has the ability to make a decision or to perhaps try to recognize that there may be circumstances involved or that there'd be no point in bringing it to us if we were compelled to issue a fine. You just issue the fine.
Some towns do, but with the process that Barnstable uses, along with many other towns here on the Cape, they give retailers a right to a hearing. But I agree, I know what you're saying, but the board is compelled to issue, to act according to the state law, which requires the fine. For a sale within a 36-month period.
Can we issue the fine and suspend it?
No.
Why?
I don't have,
Well, okay, so
you suspend the fine?
which person rendering legal opinions has a legal degree, I'm wondering?
All right, well, I might defer to my partner, colleague Cheryl Sabara.
There's, good evening or good afternoon. My name
Make
is
sure the mic's on,
Cheryl.
Cheryl. Thank
It
you.
is. My name is Cheryl Sabara. I am the Executive Director of the Massachusetts Association of Health Boards and their senior staff attorney. When this matter was put before the legislature back in 2018, I think it was passed in 2019, those of us that practice public health law explained to the legislature what increasing these fines would actually mean, because no longer could you use non-criminal disposition. You would have to use a cease and desist order in order to issue them. And the legislature was adamant that they wanted these fines increased. They felt this has been going on for too long, and they wanted the fines increased. Attorneys at the Department of Public Health enacted regulations, and they determined that these fines were mandatory. The reason for holding a hearing is to give those folks that were issued a cease and desist order the opportunity to come before you and present their case. They may claim that the fine was issued in error, that nobody sold to someone. Those are the reasons that you hold public hearings. Now, I know I've had some experience with this board in the past where you have not liked what the state law said, and you've made decisions based upon what you feel is in your judgment, even if the state law says something different than that. So I know you have done that. I've been here when that has happened. So we're just telling you what the state law requires and what every other municipality in the Commonwealth has, how they've interpreted, including their attorneys. And I wish Attorney McLaughlin was here. You could ask him as well. But every other municipal attorney has interpreted this as a mandatory $1,000, $2,000, $5,000 fine. These retailers are very fortunate that they're before this board it's your decision whether you want to comply with the state law or not.
We can only spend just so much time and effort trying to drive people out of the state of Massachusetts.
Again, I can only tell you what the law says. I
So-
didn't write it.
So what if someone comes forward and denies? They say, didn't happen, we weren't there, whatever. And so do we act as a quasi, legal board or judge?
That you are
And
holding
then-
a quasi-judicial hearing right now.
Right, but
So,
I'm
yeah.
saying that the argument that Dr. Cuniff is making is that, we have no say in this. It's
Well,
the
if you
issues
feel, if you feel that the violation occurred, then there is a mandatorily required state fine. In addition, if it's a sale to someone under the age of 21, there is also a mandatory first-time suspension of 1 to up to 30 days. that's mandatory also. Now, I mean, I don't shoot the messenger, that's just what
No,
the,
we're just
what the
asking
state law
questions.
says.
Not-
And if a retailer doesn't like your decision after a hearing, they can appeal to a court of competent jurisdiction. And again, I'm not going to tell you what to do or not to do, I'm just going to tell you how the law has been interpreted. Now, I will tell you that there is one town back in 2020 not on the Cape, but in southern Massachusetts, that issued the fine. They didn't want to issue the fine to this person, but they felt they had no legal redress other than to issue the fine, and they continued payment of the fine on a payment schedule so that the retailer wasn't hit with the fine all at once. So that is a manner that, actually, two towns did it. One gave the retailer, I believe it was 15 years to pay the fine, or 10, because it was $1,000. And the other put a less long time period on the payment of the fine. But again, I'm just telling you what the law says, not suggesting what you should do or should
I
not.
appreciate having the ability to get a legal opinion from somebody with a legal degree. Thank you. We doctors tend to give legal opinions all the time, and I have a tendency to tell them that we don't have legal degrees. So it would be within our discretion to do the $1,000 fine and then have it paid $1 a month over the next 1,000 months.
It has been done, and it was not challenged. It's been done twice, in my experience, over the past, since the law went into effect.
And as far as the suspension, we have to suspend a license.
For sale to someone under the
20
age of 21, the law mandates, the regulation mandates a suspension for 1 to up to 30 days or longer if the board chooses.
So we could do a one-day suspension. Okay, all right, thank you.
Anyone else?
My question for you on the sting operation, did the 18-year-old have a fake ID, or did they just not show an ID at all?
No, the protocol requires that the buyer goes in with nothing in their pockets except the money that they'll need to make the purchase. And so they don't have an ID of any sort. Sometimes, the clerk will ask for an ID and still make the sale, even in the absence of one. Other times, most of the time they say, no, I'm sorry, which is what they're supposed to do. And, other times they'll ask for a birth date, and they'll give an actual birth date, and the clerk can't calculate the person's age based on that, even though there are plenty of tools available for that, for the retailers. So there are a number of different scenarios which take place, but the bottom line is they go in with nothing but the money in their pockets.
So the stores are not asked to validate an ID? If
There
it's-
is a requirement in the law
Yeah.
that the stores ID everyone who attempts.
ID everyone, are they supposed to be able to validate the ID?
No, they're just supposed to ID everyone.
And was the same process used for every one of these violations?
Yes.
Is there any reason to think that these violations didn't happen?
No.
Okay.
Do you, and you use somebody who is actually 18?
Yes.
And you were present,
Yes, I was, sir. Yes.
not in the store, but
Not in the store, no, but outside. And then when the young youth comes out, they tell me right away whether they were able to purchase or not, what the price was. They give me the change. We, count the change to make sure that his number is accurate, and then we write it up on the form, and we'll go from there. And he gives me any details about the clerk that might be, identifying characteristics, male, female, what have you, hair color, mustache, name tags, those kinds of things. So,
what do most towns do with charge the fine right away?
yes, when no one else has done any
You'd
alternative.
have to set up some kind of a bureaucracy if you wanted to fine people $1,000, $1 a month for 1,000
Right.
months.
Well, hopefully, the fine structure is meant to be a deterrent, and so that's what makes it so shocking that we got so many sales, especially from a person who's 3 years younger than the legal age to purchase. And so I was personally very stunned and discouraged, because we go in and do we make a good, strong effort to go in and educate, make sure retailers understand what the consequences are. The fact that holding a tobacco sales permit is a right and not a privilege. I'm sorry, privilege and not a right. So, but to take it that lightly and not ask ID of everybody who walks in the door who appears to be under 27 or 30 years old is, in my mind, it's unacceptable, and I would hope that as purveyors of public health, that it would be yours as well, your opinion as well.
It seems like you're describing that we have a culture in this entire area of just allowing it to be sold to minors. With no discrimination at all. I work in the emergency room, and I'll often tell my patients that the one single determinant that will move you from an unhealthy category to a healthy category is whether or not you're addicted to nicotine. It's the number one thing that will destroy your health over time. And we know that teenagers, their brains are not fully developed in terms of making good judgments. And I think this is the reason you have the laws in place to make them wait until they're older. Now, they may end up choosing to use products, whether it's vaping or cigars or cigarettes, but they're way less likely to develop an unbreakable dependence, which is what I see. When you see people with, hooked up to oxygen tanks, who still can't quit nicotine, and they want to, and for decades they've been unable to quit, in the end, you just know it would be better if nobody used nicotine at all. But you have the freedom to do it. But we've been given strong laws here. I feel like a $1,000 fine and a suspension of sales for 1 day, the minimum, is reasonable, given the consequences and given the way the law is described. And unless somebody has an argument to make that this didn't actually happen as it's been described, I don't know why we wouldn't just go ahead and make a motion on this and put it through. And you know what? The practice needs to change. The culture needs to change. Okay, because I know my kids just went through Barnstable High School, 3 of them, and everybody's using nicotine if they want to. And that's the reality.
I obviously don't disagree with you. And as a former smoker who quit from a relatively high nicotine consumption when I quit, because last century you were able to consume relatively high amounts of nicotine, I agree with you. And from a public health perspective, I agree with you. But the problem is exactly what you said. And, Bob has been here on many, many, many occasions. This is the first time he's brought this many people in at once. Right. And I'm as shocked as he is, because it's not the kind of culture that seems to be pervasive. The kids that are smoking in high school are getting them from a whole bunch of different places. The people who are sitting in front of us are all over 21, and most of them are small businesses. And to the larger businesses, a $1,000 fine is a dinner out. To the small businesses, a $1,000 fine is the mortgage payment and whether or not they're able to maybe hire another employee. And I just think that we're going about it the wrong way, which, to be honest, and you've, I think, seen my bias, is a fairly common approach here within the Commonwealth when it comes to the people who are smarter than us in Boston who decide how we're going to do things going forward. And, these people are trying to run a business. They're not trying to run afoul of the law. And normally, and in the past, when they've gone out there, they've not sold tobacco products to them. I agree with you. We have no choice but to do the $1,000 fine. I would tend to be a little creative in how I would apply that $1,000 fine, probably more so than it sounds like you would want to be. And I think the minimal suspension is there. I think we need to make clear to the folks in the room that they really have to make it clear to their employees, but we also need to recognize that they don't control all of their employees. Some of their employees are stupid teenagers who made a stupid decision, just like the stupid teenagers who were trying to buy tobacco from them. And we can only make it just so hard to live on Cape Cod and in the Commonwealth before we, as I said, drive even more people out of here. So, as a physician, I agree with you. Smoking is a horrible, horrible thing, and we see horrible results from it on a daily basis. And I wish we could somehow abolish tobacco, but unfortunately we can't.
Tom, did you have something? Yes.
I'm agreeing with you guys in terms of the health argument, but sitting on here and thinking, I'm not a smoker, okay? But thinking, I mentioned before, way long time ago, several years ago, that my father is a smoker, a long-time smoker. So I kind of hate that. And then, I can understand you're a small business, and this is a big deal in terms of 1,000 fines for one times. So to me, I'm more of a lenient in terms of the fine, but if it come back in a year that you still show up these violations, I'll be heavy on the fine.
Yeah.
Okay? So that's my comment.
Yeah, I apologize. I thought it was a hearing where we had more say. And
Yeah.
if that's not the, wishes of the board, I'm still very confused as to why there's a hearing then. If it's shall be a fine issued, then just send them a bill, and why do we get involved?
Well, the previous licensing director years ago started this requirement that they come to the Board of Health for a hearing to determine if they're guilty or not guilty before we issue the fine. That's the reason for this hearing.
The legislature wrote it shall, so it shall be issued. The fine shall be issued. So
And I know that we're probably one of the only one of few times.
I misinterpreted. I thought we had a say in it. I thought we had leeway in determining that.
Well, we used to. We used to have a
Right.
leeway.
But it sounds like 3 years ago, 2018 or whatever, 20, it was changed.
As, Mr. Barr said that the legislature that did it.
Well, we do have leeway on 1 to 30 days suspension.
Yes.
That would, I imagine a 30-day suspension of your tobacco license is a lot of money.
Please don't say that they pay $1 for 1,000, because I have no control on that part. That would be something
you'd
they
have to
they
set
could
up
work it out
something
with the
with the
court.
town.
No, I'm not in favor of that, but
Yeah.
if we can put it to a vote, but I'm not in favor of, if it's a fine, if the state legislature writes it up that way and took away any, leniency or discretion on our part, then I'm really confused as to why it's in front of us to begin with, and let the staff issue the amount of days based on, the amount of things. But, we got to move forward. We're, running along a little bit. I did want to get through all these. If there's no need to debate, there's no need for show cause. It says the fines have to be issued. Then what are we voting on?
I would still propose that the fine be, by the way, $1 a day or whatever I came up with was not, but I would still follow suit to the towns that were making the statement as to, and that they were making the same statement, I think, as to how ridiculous this is, as I'm trying to make.
That's exactly what they said. But they gave a
There are 3
period of time.
libertarians left in the state, I think.
A few. But they did it over a set amount of time, like you have a year to pay the fine, or you have 6 months to pay something
Yeah.
not it was just that one town. There are only 2 towns that have done it this way. One said 15 to 10 years, and the other said, I don't remember if it was 6 months. I don't remember what the time period was, but there was a time period given.
I like 10 years, but I'm probably going to be on that one.
I suppose they could appeal the ticket to the clerk magistrate and then try to work out a payment plan there, but not with us. That's, I don't think that would,
So when,
I could
my question
handle
is,
that part.
from a, like, how do you word something that is shall? It's like, if someone has a speeding ticket, it's a speeding ticket. You either go to a court, you fight it, or you don't. I mean, if we want to sit here and, go through all 20 of these and listen to each person explain why they don't think it happened or waited, I mean, if that's the process, that's the process. We'll never do this again. I'll only allow 5 at a time. We'll never do 20. I had no anticipation of hearing from every single person and making a ruling on it, because from what I'm hearing, we can't make a ruling on it. We can't make a determination that it didn't happen, or it's just, if they determine it happened, the legislature says, from what Dr. Caniff read, it shall be a fine. So how do I word, or as a chair, how do we make a motion to do what? Like, what are we doing? The fine's already been issued.
Dr. Letzko said we still have a determination to make as far as suspension timelines for
Okay,
each.
so we can make a,
And we can decide the time period over which the fine is going to be applied.
It's,
I mean, we do have the ability to do that. Other towns have done it.
yeah.
By the way, I have no doubt that they have a good program in place, and I'm not at all questioning whether or not we would end up agreeing that everybody got caught. I mean, that's, I'm not in any way implying that there's not a good program in place.
Is that the way it's written? Is that the Board of Health has jurisdiction over the duration of the suspension?
It's
Only?
silent on when the fine needs to be paid.
Not the fine. My question is
Yes, it's written that the fine for selling the first time to someone under 21, not for selling flavored or anything else, just for selling to someone under 21, can be from 1 to 30 days or more if the board so desires, is what the law says.
And that's the only flexibility.
That's the flexibility. And again, the hearing is to determine whether, in fact, the sale took place. That's the purpose behind offering a hearing.
So are we or aren't we required to do the suspension?
You're required to do a suspension
You are,
from 1
okay.
to 30 days.
Okay, all right, thank you.
So if someone comes forward and makes a compelling case that they don't think this happened, and
It's your decision.
and then we go back to now we have discretion, where that's the problem I'm having is
Well,
the
you
way it's
have to
written.
determine you're acting as a quasi-judicial board when you're entertaining hearings on violations. So in that, when you're operating that way versus quasi-legislative, if you're looking at regulations, if you're acting as a judge, which is what you're acting as at a hearing, then you weigh the evidence from Mr. Collette and you weigh the evidence from the retailer, and you determine whether or not the violation occurred. And you make a decision based upon what he says and what the retailer says.
Doesn't a judge have the discretion to also apply whether or not it appears to be a just decision? Or just
No,
punishment?
the way the law is written, if you determine that a sale was made,
Mm-hmm.
it's a strict liability offense. It doesn't have any, you can't look at intent or extenuating circumstances. You have to determine whether or not a sale was made. Just like whether or not someone sold a flavored tobacco product. Same thing. That's the decision that the board makes.
Okay, we've got to get through this. So,
John, why don't we ask
well, we're
the
going
business owners?
no, we have to go through one at a time. Then we're going to have to call each person up, have them make their case, and determine each one individually. And it's just going to have to be that way. But
If anyone wants to make a case. If anyone
well,
wants to.
yeah. I mean, I'm going
claim that-
to go call each one up now, and I'm just going to say, do you want to make a case, or you just want to accept the fine and make a motion for a 1-day suspension of your tobacco license?
Very good, okay.
Sound good to everyone?
Yeah.
Okay. All right, so with that being said, Barnstable Bottle Shop, 10 Seawood Road, Hyannis. Come forward, please, and make a case.
Guilty.
Thank you for your time. Have a good afternoon. Thank you. Okay. So they're guilty. Make a motion to suspend their license for 1 day. Entertain a motion?
So moved.
Second.
All those in favor?
Aye.
License has been suspended for 1 day. The mandatory $1,000 fine has been applied.
We didn't ask for it.
Place, how do I know, like, is it tomorrow or?
That's up to you.
It takes me about, in this case, longer than perhaps a week to write out 19 tickets, if that's the case. So give me
Okay.
about 14 days to write out these tickets and send them in the mail, and then you have 21 days to pay, I believe, to pay the ticket or to appeal the ticket.
And then yeah, I think he's asking, when is the 1 day suspension?
That would be determined by the board. I would select, I would push it out.
But once he receives your
Can-
ticket,
Yeah, you want to make it 1 day certain in March
What
sometime?
difference does it make?
Can we make it,
You're not-
are you open Christmas Day? Yes. Oh. Is there a day you're closed?
Is there a day that you tend to have fewer sales?
Any Monday is fine.
Any Monday? Okay.
Okay, so pull out your calendar, Sharon.
but
Well, Tom needs 2 weeks to issue the
Nobody's
fine.
going to go out and monitor whether they're closed.
A week from Monday
So what difference?
Well, they're not going to be closed.
Monday, March 20th? Monday, March 20th.
Okay.
1 day suspension of your liquor license. Thank you.
No.
I'm sorry, misspoke. See, I get confused here.
It's not good.
Tobacco license. We don't have any authority with the liquor, because that's healthy. Cape Mart, 130 Center Street, Hyannis. Come forward, please.
What day was that again? I'm sorry.
March
20th.
20th.
Monday, March 20th. Thank you.
Good afternoon, Mr. Chairman. Paul Tardif for Cape Mart. First of all, I think you had 19 violations because I think it was, whoever they sent in, I don't think it was 16 or 17. In fact, they had to create a separate box on the form for 18. And I think, it'd be fair to take a look at this gentleman and hear from him if that's what you have to do. If you still find that there's a violation, we would take the suspension on Christmas Day. And if you're going to impose a $1,000 fine, why don't you suspend it for the 3 years until, if we don't come back, then it's gone. But I think if they're going to make the case that the sale's made and he wasn't in the building, I think we want to hear from the person.
Where is he?
And they want the guy, the kid they used, he feels that they should be here testifying.
Well, okay.
The reason I'm asking
You're
is
implying
because-
that he didn't use somebody who was 18 to,
No, but if you take a look at him, I think you're going to have, if you have some discretion in whether this violation occurred, I think we want to hear from him. The second, if you have no discretion, I agree with you. What's the point of this?
Right. I mean,
And
it seems to be they're asking us to determine a 1 to up to 30-day suspension of tobacco license.
I mean, if you have to impose it, but just suspend it. And a $1,000 fine for these small businesses, I agree with you completely. It's, and I know it's the law, but I think you still have some discretion in what happens here. So I'd ask you to do that. We understand the severity of it. We respect it, but again, if it's going to come to that, then let's hear from the gentleman, the only person who was there. When he, according to this report, he made the sale and left. We don't even know who it was, and then we noticed a violation well after the fact. We don't know who it is. How can we correct it? So we'd like to hear from the gentleman.
What's the typical response of someone that challenges it? What do you have? Do you keep logs? Do you keep records?
Well, yeah, we write a report as soon as it happens, and,
You can read the report.
yeah, you can read the report, and
We can just read it to him.
so on January 9th, 2023, at 12:04 p.m., 18-year-old male entered Cape Mart at 130 Center Street and requested a single black and mild cigarillo, which was sold to him for $1.80 by an adult male.
And then do you go right back into the store and issue the?
No.
Or you
There
wait
was a
and-
day when we did that, but, they set up, phone trees and so forth, and everybody gets word quickly that we're out, so that's, it's ineffective.
Okay, so then it's, the paperwork is mailed to them and say
Yeah.
on this date is that, okay.
Right. The violation is they're notified of the violation by the local municipality,
Okay.
which is reported to them usually within 24 hours to the municipality.
Okay.
And who created this report?
That was me.
And you weren't there?
I was there, sir. I was
You were
not
outside?
inside. I was outside, yes.
Okay.
Yeah. Which has
never
been
happened.
the standard procedure for
Never happened.
28 years.
We're going to,
So,
all the fines, it never happened.
so the young man goes in,
Yeah.
buys it, comes back out, sits with you in the car, you fill out the,
Yeah.
okay.
Yeah, and he doesn't magically appear, a cigar doesn't magically appear in his pocket. His pockets are empty when he goes in besides the money that he brings in, yeah.
Obviously, if there's any question, I'm not in favor of this. On the other hand, I'm not going to impugn the people who are trying to do their job and sound like they're trying to do it well and correctly.
Understood. I just think, if we're going to talk about equity, I think we need a little fairness as well. And I also question whether he had something else in his pocket when he walked in there. Because we've seen him. And he had something else in his pocket other than money.
But just from his testimony, he's just saying no.
Right.
Okay,
I would trust
Okay.
him.
Yeah.
but-
okay.
Yeah.
So,
Can I ask one question?
sure, go ahead.
Sure.
Does he get a receipt?
Doesn't ask for one because it's not common, it's not common for people to ask for a receipt, an 18-year-old or a 21-year-old, even if they're going in to buy a cigarillo. Oh, could I have a receipt, please? They do accept them if they're offered.
Yeah.
Yeah.
I can't say I'm very happy with the direction this is going. But I do see the point that, on a second or a third violation, when things get more significant, much more significant, a lawyer is going to ask for proof, definitive proof, more than just personal testimony, something. So I'm not sure how that's going to be provided. I'm not inclined to ask for it today, but I think it's something to consider going forward. The board could be utterly tied up with contention such as this, that it didn't actually happen,
Right.
which doesn't seem very likely.
Normally,
But
there's
could be-
video that, usually when an attorney represents a client and comes before the board, there are two sides. There's the inspector side, and then there's the retailer side. And usually, you can ask for video from the store that shows the sale either happening or not happening, and usually the retailer comes and testifies as well. And that's how it goes. I mean, that's how I've seen it
Okay.
numerous times.
So the shop owner was provided with the time of the violation.
Right.
And presumably, if the shop owner had a video camera running at that time, they could have brought in.
Which they all do.
And they
Yeah.
have a
Didn't actually
receipt, they have
happen.
their own tape
Yeah.
Yeah,
on their machine.
okay. So does your shop have proof that it didn't happen?
Only good for 2 weeks.
Yeah.
Wouldn't you enter
They're good for 2 weeks, the tape.
And we got notice.
And we got notice after that fact, so.
Okay, that's
Nothing.
something to keep in mind going forward.
I thought you said the municipality notified them the next day.
No, I notify the municipality within, so then wherever it goes from there, yeah.
Okay, so Cape Mart, 130 Center Street, Hyannis. Entertain a motion for one-day suspension on 12/25/2023, and the fine to be applied as per state law. Have a motion?
You have a
Died for
motion.
lack of motion.
Second? I have a motion and a second. All those in favor?
Aye.
Aye. Fine's been issued, and a one-day suspension on 12/25/23. Centerville Food Shop, 1620 AK 1638 Falmouth Road, Centerville.
Yes, sir, we made a mistake. We are in violation, and I'll take suspension for 1225 on a Christmas day, and a fine.
Okay. Centerville Food Shop, 1620 Falmouth Road, Centerville. Fine, state mandated fine to be applied, and a one-day suspension of tobacco license on 12/25/23. I'd entertain a motion for that.
So move. Second.
I have a motion and a second. All those in favor?
Aye.
Cumberland Farms, 1165 AKA 1171 Iona Road, Hyannis. Is anyone here from Cumberland Farms?
How you doing? I will accept the fine and the one-day suspension. When do you,
Any Monday, doesn't really matter.
March 20th?
March
That's
20th?
gonna be fine.
Okay. Cumberland Farms, 1165 Iona Road, Hyannis, accept the state mandated $1,000 fine, one-day suspension of tobacco license on 3/20/23. I'd entertain a motion for that.
So move. Second.
I have a motion and a second. All those in favor?
Aye.
Thank you. Luke's Liquors, 132, 1166 Iona Road, Hyannis.
Good afternoon, board members. I'm going to be an easy fine. I just wanted to have a minute, if I could, to just express a couple of thoughts. I sent something forward. I don't know if you received it. Did you all receive it?
Yeah, we all read it.
So
Thank
I
you.
need to pass
Thank
those
you.
out. I did bring my store manager and the person that did, sell to the minor. I have footage, transparent. We sold to the minor. So this is a copy of the, I don't know if you want it or.
Sure, you can give it to the secretary. She'll just put it in the file.
These are warnings. I like to throw myself under the bus. I feel like it is a double violation for me, because both stores fail. So to me, it's, this is embarrassing. I can't even believe I'm here. I think, as he spoke to, having so many people caught, that the gentleman that they used was, older looking, but at the end of the day, I expect my staff to card as if it's alcohol. So this kid should have been carded. I think if they continue the stings, they should use a 21-year-old that is actually young-looking, because I don't think there's any viability. It's not legal to use an underage person to do this. So I think that'd be some advice I'd have for them, even though, this person could, have the same success with us. But it should be someone that's of age. Not, I think when the liquor people do stings, they have to use someone that's of age. They just don't go in with, they just don't have their ID. They don't go in with like an 18-year-old, because it's illegal to perform that sting in that manner. I guess, what else do I want to say? Maybe they should use a body camera. That might help them. I'm trying to throw myself under the bus more. But if they have a body camera, they might, be able to have good proof. Cigarette business isn't really, there's really no money in it for us. If you took all the cigarettes away from all the package stores, I'd love that. We wouldn't have any, we wouldn't carry cigarettes. But the fine's kind of stiff at $1,000. Being closed for a day, I think, is a better option. So I'm going to let you take that option. I think being a smart businessman, I hope that you could give me a different date on the 20th, because if everyone goes on the 20th, all the other people are going to get all the business. So I'll take a different date, a single date. Other than that, I don't want to take any more of your time. I probably had some more things to convey, but I apologize for us being in front of you today. And
Thank you for
it
that.
won't happen again.
Can I ask?
Thank you.
Thank you.
Sure.
Do you prefer a Monday like?
Can I just ask you a
27.
question?
Mr. Luke? Sorry.
Did you have cameras?
Yes.
So you saw
I've
the
got
person?
the person right here, yeah.
You got a picture?
Oh, yeah.
Unfortunately, they all look young to me at this point. Yeah.
Thank you.
You can-
Thank you, by the way, for that letter, too. That was a very,
Thank you, and I'm
Yeah,
sorry.
thank you.
You can stay up, because we have to do each one individually, unfortunately. So Luke's Liquors, 132, 1166 Iona Road. I would entertain a motion to assess the $1,000 fine as state mandated and recommend a one-day suspension of tobacco license for March 27th, Monday, March 27th?
Am I getting the $1,000 fine?
Yeah.
Okay.
There's
Did
no
everyone
leeway.
prior to get it?
There's no leeway.
Okay, that's fine.
That's
Did everyone prior to get that?
everybody.
Okay,
It's,
okay.
I came into this meeting assuming we had some leeway. I was corrected on that.
Oh, yeah, and
So
I tried to
yeah.
extend it over a 10-year period.
I appreciate
we don't have
that.
the staff to collect that,
You
so
you might not be in business 10 years from now, so you wouldn't be able to collect it all.
sorry about that.
2 different days if I could.
Sure, absolutely.
And-
And there's just this one, we have to do each one individually, I'm sorry. And the suspension for the tobacco license for 3/27, okay? I'd entertain that motion.
So moved.
Second.
I have a motion and a second. All those in favor?
Aye.
Luke's Liquor, Super Liquor, 395 Barnstable Road, Hyannis.
Yes, sir.
No additional comments. I entertain a motion to assess the $1,000 fine as per state mandate and recommend a one-day suspension of the tobacco license for pull up the calendar, sorry. 4/3, Monday 4/3?
Yeah, yeah.
Fine, okay, Monday 4/3. I'd entertain the motion.
So moved.
Second.
I have a motion and a second. All those in favor?
Aye.
Now, that's not for you to be closed those days. You just
It's
can't.
just the cigarette sales.
Just the cigarette
Yes.
sales.
Cigarette sales. Thank you for that.
All right, that was.
Those are those two. Thank you so much. Mid-Cape Service Center, Mobile Mart, 2145 Iona Road, West Barnstable.
Me again. Christmas Day, please.
Okay? I'd entertain a motion to assess the $1,000 minimum mandatory fine for from the state legislature, and a suspension of the tobacco license for 12/25/23.
So moved.
Second.
I have a motion and a second. Yes.
Yeah.
So moved. I have a motion and a second. All those in favor? That's unanimous. Mobile J&J Auto, 381 Camp Street, Hyannis. Welcome, sir.
No dispute.
Okay.
Christmas Day would be great,
Of,
and appreciate the board's attempt at leniency.
we tried. So I would entertain a motion for acceptance of the issuance of the $1,000 minimum fine for J&J Auto, 381 Camp Street, Hyannis, and a one-day suspension of the tobacco license for 12/25/23.
So moved.
Second.
I have a motion and a second. All those in favor? Aye. That's unanimous. Osterville General Store, 16 West Bay Road, Osterville.
How are you?
Thank you. I'm well. How are you?
I'm good, sir. March 5, sir.
March 5th?
Yes, sir.
Okay. Thank you for that.
Thank you so much.
I'd entertain a motion for Osterville General Store, 16 West Bay Road, to assess the $1,000 fine as mandated by the state, and a one-day suspension of the tobacco license for 3/5/23.
So moved.
Second.
All those in favor?
Aye.
Sam's Food, Santuit Gulf, 4738 Falmouth Road, Katuitt. Welcome.
How you doing?
Great.
Guilty, Your Honor. All right,
Okay.
Sir,
Don't call me that, please.
yeah, my bad. Is there any way I could do 4 installments on the fine, and then can I take Christmas Day for that?
We don't have the staffing. I mean,
so just-
knowing this going forward, if, I'm going to talk to Tom about staffing, because someone has to, process the checks. I understand this, and we tried our best to help you guys out. This is painful for me to have so many local businesses assess this, and that's why, if you notice, I keep saying it's by mandate of the legislature, because I want everyone to understand they did this, not me. So I can appreciate that. If you can't make the payment, that would be something you could maybe work out with staff as far as a timing for us. I don't want to put it into a policy or writing right now.
I suggest, or the other option is appeal the ticket, and then when you go before the clerk magistrate, ask for a payment plan.
Well, either that or you are asking for $250 increments.
Yeah, 4
per
installments.
month, or
Yeah, rough, something like that.
Or every
I
other
figured
month,
it
or-
out. Yeah.
so if the fine were payable 8 months down the road at $1,000, that would give you long enough to save up for it?
Tom, what's the process? You issue it, would you say it takes about 2 weeks for you to issue the fine?
2 weeks in this case, because there's so many, you'll get it in the mail in about 2 weeks, and then you can check off the box in the bottom to appeal the ticket and mail it in to the clerk magistrate. That's what I suggest. Then when you go to the courthouse, you can ask for a reduction, or you can ask for a payment plan, see what they say there.
So they have the ability to reduce the fine?
I'm not sure, but
This is, normally, the district court hears cases pursuant to non-criminal disposition, and those fines can't be above $300. So there's a question right now as to whether clerk magistrates in district court actually have the legal authority to hear appeals of these cases. And we have talked with the clerk magistrates, and it's still up in the air. The Department of Public Health, legal thinks, and many attorneys, including Boston and Chelsea, have instructed their retailers that they need to go to Superior Court in order to appeal the fines, that the district courts don't have the legal authority. But some of them have entertained it, and I know Somerville District Court has reduced fines.
Okay. Well, if nothing else, that buys you time to save up for it.
Yeah. And then can I just do Christmas Day, 2023?
Yes.
Thank you.
Okay, and this was Sam's Food, 4738 Falmouth Road, Katuitt. I'd entertain a motion to assess the $1,000 minimum fine and to suspend their tobacco license for 12/25/23.
So moved.
Second.
I have a motion and a second. All those in favor? Aye, that's unanimous. Speedway, store number 2429, 149 North Street, Hyannis. Thank you for your patience.
So Speedway knows that selling tobacco products is a privilege. We also know the importance of being a responsible retailer, and we do not take the sale to an underage person lightly. We have a zero tolerance policy at our company. So the day that I received that the sting occurred on January 9th, they typed up the letter on February 7th. I received it February 13th and terminated all employees at that moment.
Thank you very much for your vigilance on this. Unfortunately, we don't have, if you heard, we don't have much leeway on this. I
know.
apologize. Is there a particular day that you would prefer the license suspension, one-day suspension?
If I could also choose Christmas Day, please.
Certainly. And this is just the one store. We have to do one at a time. I apologize. But
Okay.
this would be for the 149 North Street Hyannis store, Speedway store number 2429. I would entertain a motion to assess the minimum $1,000 fine and a one-day suspension of their tobacco license for 12/25/23.
So moved.
Second.
I have a motion and a second. All those in favor?
Aye.
That's unanimous. Second Speedway store, store number 2442, 156 Iona Road, Hyannis. Same thing, we entertain a motion for a assessment of the $1,000 minimum fine, as mandated by the state legislature, and to suspend, do you want a different day?
May I just choose the same day, please?
Okay. For Christmas 12/25/23 for the suspension of their tobacco license for one day.
May I ask one question?
Certainly.
Actually, two.
Sure.
If for some reason that store had to be closed on Christmas, do I have to notify someone?
No, because your tobacco license will be suspended for that one day.
Okay. And
So it's, if the store is open or closed, it doesn't matter to us, and that's why I'm trying to give the people option that if it happens to be like, oh, we close for a certain day for
Okay.
employee benefits day or something, we'll suspend your license for that one day.
Okay. And my second question was, do I have to remove all of the tobacco from the premises on the day of suspension?
Yeah, unfortunately you do, or cover it.
Cover it? That would,
It's supposed to be physically removed, but
But yeah, physically, if you can, remove them all for that one day, yeah. But I mean, if it's in like a case behind you, if you just, I've seen in the past, and I think, Bob, if they drape it, it's like, I know
we
it's,
haven't done it, and not here in Barnstable. I've seen it in other places, but
if it's not specifically spelled out, then I'm going to let you drape it.
thank you so much.
Can I just, how many people did you fire?
I had to fire 2 people, one from each store, the person that actually made the sale, which I reviewed the video, and unfortunately, the woman that failed at the 2429 store, she had just passed the bars. We used the be irresponsible, okay. So she had just passed 2 days prior with them. And at the other store, the 2442 store, the person that I had to fire from that store, he'd actually passed 3 times in a row prior to this day. I've watched the video over and over. I still don't understand why. I saw the hesitation and then them make the sale. And because it's zero tolerance, I couldn't even get
Were either of them problem employees?
No, long-term employees, but it does, zero tolerance is zero tolerance. The woman was a single mother. It broke my heart, but the law is the law, and I had to.
No, you just thank your legislators.
Thank you so much. We didn't take a vote on this yet, so just entertain a motion to assign the minimum $1,000 fine per state legislature mandate and to,
Christmas.
Christmas Day 2023, to suspend the tobacco license one day.
So moved.
Second.
I have a motion and a second. All those in favor?
Aye.
Aye. That's unanimous. Thank you so much for your time. Tobacco Master, 606 Main Street, Hyannis.
Yeah, Mr. Chairman, Mr. Jamal is the manager and the owner. He'd like to address you if you could.
Sure, come on.
Hi, gentlemen, good evening. My name is Asman Jamal, and I'm representing Tobacco Master, 606 Main Street. I just have one question. I'll agree that $1,000 and suspension. 15 years of in this business, running in this town with no tickets. I have other locations too. And one of these locations opened in 2019 because they banned the menthol, so we have to get into the smoke shops. So we got into that and the state banned it. So we take, and then all of a sudden the COVID hit, all right? So it's 40% sales down. I'm not saying that we made a sale like this. We made a mistake. But it's my word against him. And he's saying that he sent somebody in, right? How we can prove that somebody came in? I can document something and I was not even here. If you have no
Yeah,
reason.
and we're sympathetic to that, and
So-
I would say moving forward, you should try and keep your tapes longer than 2 weeks, or if that's the standard, I don't know. Some have DVD loops that are 30 days. I've had experience with that before.
But the question is, if they are doing sting operations, isn't this their responsibility to have something proof?
Well, they just have the two people involved in the paperwork. I mean, we don't, look, the bottom line is they're not doing this to punish
I
people.
know,
They're not doing
I
this to hurt
understand
people.
that.
They're doing it because the state legislature, the elected body that represents the people of Massachusetts, had put a high priority on this. They wouldn't have done this lightly if they didn't put a high priority on it. So the advice moving forward is card everyone. If Santa Claus comes in with a beard and white hair, card them, and then you won't ever have to worry
I
about
don't
it.
understand that. But my suggestion is that I'm just suggesting if you're doing a fine, can we just have the suspension taken off? It's just a suggestion.
It's, yeah,
I'm just saying
from what I've been, look, I was educated today. I thought it was, we had some leeway on this. What I've been told, and Dr. kind of brought to our attention is that it shall be. So there's a $1,000 minimum fine, and then the only leeway we have is to suspend your tobacco license for 1 day or up to 30 days. And so I'm putting it forward as 1 day. If someone on this board says, well, wait a minute, I want it to be 15 days, I'm going to allow that to go to a vote. I'm not going to support it, but I'm just chairman. I'm not, the ruler up here. So we're trying to be as lenient as possible with this, and unfortunately, like I said, moving forward, I would recommend businesses card everyone. I know it's inconvenient, you have 10 people in line, and you have an employee, and you're carding every single person that wants
You
tobacco.
hit the same person 10 times, he's going to make a mistake one time. You're not perfect.
And they
So I'll
just
just-
ask for it every single time. Unfortunately, we have no leeway.
I get it. So I'm going to just take the 25th,
Christmas Day? Okay. So the Tobacco Master, 606 Main Street, Hyannis, I would entertain a motion to assess the $1,000 minimum state legislature mandated fine and suspend the tobacco license for 1 day, which would be 12/25/23.
So moved.
Second.
I have a motion and a second. All those in favor? Aye.
Thank you.
Thank you so much for your time. United Gas, 199 Falmouth Road, Hyannis. Good, how are you, sir?
Guilty. I'll take Christmas Day, please.
Okay. United Gas, 199 Falmouth Road, Hyannis. I would entertain a motion to assess the $1,000 minimum state mandated fine and to suspend the tobacco license for 1 day, and that day being 12/25/23.
So moved.
Second.
I have a motion and a second. All those in favor?
Aye.
That's unanimous. Thank you so much for your time. Willow Package Store, 696-700 Yarmouth Road, Hyannis.
Hi, good evening.
Good evening, sir.
Yeah, my name is Shakil Farouk, and I come from the Willow Package. That day was 9th. I have a trainer, hire a new employee. This time hiring very hard people. And I think that delivery day coming, sometime go back there for taking the delivery, and the trainer was there, and I have a proof. Then next week, he was, back in his job, but that day is happen.
It's unfortunate, and I think of a store I was in off Cape the other day, and big bold letters is, I mean, I've never been a smoker, I'm not a tobacco person, I don't, nothing, but as soon as I walked in, there was a big sign that said, "We card everyone." And so I thought, well, that's one way to avoid any problems. They just, doesn't matter. If you don't have a card, don't bother asking them for any tobacco product, because obviously they had a town that issued multiple fines or whatever because of mistakes. We understand that. And believe me, I came to this meeting tonight thinking that we were going to give everyone a little bit of leeway and don't ever do this again next time, but I was corrected and educated. So unfortunately, our hands are tied on this.
Thank you. So
Thank you very much.
December 25th.
December 25th? Okay.
Thank you.
Willow Tree Package Store, 696-700 Yarmouth Road, Hyannis. I would entertain a motion to assess the $1,000 state legislator minimum fine and to suspend their tobacco license for 12/25/23 for 1 day.
So moved.
Second.
I have a motion and a second. All those in favor?
Aye.
Aye, that's unanimous. Willow Tree Market, 15 Charles Street, Hyannis.
1225, please.
1225?
Yeah, thanks.
I would entertain a motion for Willow Tree Market, 15 Charles Street, Hyannis, to be assessed the minimum state legislator $1,000 fine and to suspend their tobacco license for 1 day on 12/25/23.
So moved.
Second.
I have a motion and a second. All those in favor?
Aye.
That's unanimous. Thank you. Now, the Smoke Hub, Riley Chaudry, 145 Barnstable Road, Hyannis, map and parcel, 2 different tobacco violations in 1 month, 12/28/22 and 1/9/23.
Yes, hi. So the first violation, I'd like to put aside for the second, go to the second one, which was the January 9th, which was, again, the sale of cigarettes in that one. So again, if we have to pick our day, we'll pick the 25th again. But on the first violation was a little different because that was an inspection done, I believe it was by Mr. Collette. So it was a routine inspection done in December of '22. And you can see from the paperwork, this is a tobacco shop. And Mr. Collette inspected the signage, the location, the products for compliance with the tobacco law that went into effect, I think it was 2019, 2020. He's done those routine inspections over the last 2 years and came into the Smoke Hub in August of 2022. At that time, he did his inspection. He spoke to the owners. Course of their discussion, it was my client's impression that there was going to be an amendment to the law that would make it illegal to sell flavored wraps, papers, and the like. So the implication was that there was something coming from the legislature soon that was going to change this law. In October of 2022, my client had still not heard about this amendment. So my client emailed the licensing office here in Barnstable and asked for a copy of the new regulations because he was told there were going to be new regulations regarding these wraps. He also expressed his concern to the department that he had a lot of product in stock and was wondering when was this going to be effective? Was it going to be January 1st? What was going to happen? Mr. Collette responded by saying that the law had not been amended, but that it was just going to be enforced. It's been 2 years, and I think it said 2.5 years in his email, and they were going to start enforcing what was already on the books, which was news to my client because he'd passed all his inspections with the same products. He was buying those products from a Massachusetts distributor, and they were on the shelf, out in the open, with no violations. And then suddenly, this violation occurred, and it was surprising to him because he thought there was going to be a change in the law, amendment by the legislature, not just a selective enforcement, and now it was going to be more stringent enforcement. So I think on that violation, I don't think that this really warrants any fine or any suspension on this one. And if you're thinking about a fine, just understand that after that violation, he had to destroy approximately $5,000 worth of product that he doesn't sell anymore because of the violation. So look at other inspection items on that report. You can see that they are in a good location. a fair location. And I really think that this was a misunderstanding, and he's already been punished financially. I think the additional fine would be a little piling on this one, so he's going to get the $1,000 for the cigarette sale anyway. So I think if you have leeway, I don't know if you do, but if you do, I think that this is a valid misunderstanding on their part. So I hope you take it into consideration.
Thank you for that.
Thank you.
Bob, can you just speak on the first violation and then the second one, please?
Yes, thank you, Mr. Chair. Relative to the inspection, which took place on December 28th of 2022, it was a follow-up to an inspection that I did over the summer, and at which time I approached it as an educational visit rather than an enforcement visit.
The summer one.
The summer one.
Do you have the date for that?
I'm sorry, yeah.
What was the date for
I
that?
don't. I thought it was in July. I don't have an exact date.
August.
Okay.
It was August, maybe, but anyway, at the time, I had a discussion with the owner, manager, about a wide variety of products that they were selling there, some of which are illegal. And I have some documentation for the board to take a look at relative to those. They're called Delta 8 and Delta 10 flavored vaping liquids. And they had a large amount of those, which I advised that he should remove from the shelf because they're illegal, that he wasn't in trouble for it. He also had flavored rolling papers, which were a violation of the Massachusetts flavored tobacco or tobacco paraphernalia law. They're considered flavor enhancers, and among other things. So as a follow-up to that, I stopped in December, and well, at the time of the initial visit in the summer, all those products were taken down. So I expected that they would remain off the shelves, and we weren't going to take any action on them. I told them that we weren't interested in, hurting him anyway. Just wanted him to be advised that these products are illegal. So I went back in December, and everything was back up, plus some. And the humidor was open. Those are supposed to be locked under the terms of the town regulation. So I again advised the clerk that was there at the time that the products were illegal and needed to be removed, and he refused to take them down. So I just left it at that, came out, wrote it up, and submitted it to the board for further consideration. But I'd like to just share with you some information about the Delta 8 products. I try to tell the retailers to sell anything that could possibly be illegal, and there are a world of products out there that they're confronted with or introduced to every week, that if a product can either be smoked or vaped and it's flavored, it is therefore illegal in Massachusetts. So it's a simple way to remember whether or not you should be able to sell something or should be selling a product.
Thank you.
Thank you.
Thanks.
And then the January 9th violation was that a sale to?
That was an illegal sale.
to
We got
minor.
that. The triumvirate right there in that corner. I was very surprised because those stores haven't had a long history of, they've had a long history of not selling. So I was quite surprised.
And the, what is the, what's our mandate? What do we have to, what do we have to do?
Again, you
for
determine whether or not what
not
Mr.
on
Clark-
the sale to minor,
Right.
but just on the
Okay, so
the product.
here's
that-
what the law says. The law says that a tobacco product flavor enhancer is any product designed, manufactured, produced, marketed, or sold to produce a characterizing flavor when added to the tobacco product is illegal. So what Mr. Collette is saying is that flavored rolling papers, flavored hemp wraps, and I'm going to leave Delta 8 out because that's illegal for lots of different reasons, not just for the tobacco violation. That the rolling papers and the flavored hemp wraps are tobacco product flavor enhancers as defined, and therefore, and this was Senator Keenan that added this to the state law, that those are illegal.
And what is our minimum mandate as far as punishment?
If you find, if it's a first offense, there's no suspension. It would just be first offense, $1,000, second offense, $2,000, third or more, $5,000.
For having illegal product on the shelf?
Correct.
And then separately, the sale to minor is a separate $1,000 fine?
Correct. One would be a
Still.
first offense, one would be a second offense.
So the first offense would be no monetary, but a one?
Would be the monetary, which was the first offense,
The sale.
the sale.
No, the first offense was the flavored, I'm sorry.
Yeah,
It was
the
the
first
flavored,
offense,
sale
the
of flavored
flavored.
products, yeah.
There's no minimum fine on that?
No,
And
not
there's-
not for selling
No
flavored
min-
tobacco products.
Suspension, he said fine.
Oh, you mean suspension?
Right.
Yeah, there's no suspension on a first offense unless it's selling to someone under 21.
Right. But, so the having the wrong, having the illegal product on the shelf, we have the right to not fine and not suspend.
You don't have to suspend.
And-
It's a first offense, and it's subject to a $1,000 fine.
The fine is mandatory.
Fine is mandatory.
Okay, that's what I was trying to get to. What are we mandated to do with having the product on the shelf that they're not supposed to have?
If it's the first offense, it's a $1,000 fine,
Even if it wasn't sold?
even if it wasn't sold. It's if you're causing it, if you have it on the shelves,
I get it.
Yeah, it's two separate incidents.
Mr. Chairman.
Yes, go ahead.
It was on the shelf for 2 years after this law went into force.
Does he remember him coming in July and issuing a, educational,
It was,
that
it
should
was,
not?
and that's why we reached out to the town to find out more information. We didn't just let it go. The email from Mr. Collette back to his, I'm not sure who this person was, someone in the office, was, I've been advising, this was October 17th, I've been advising retailers that during COVID-19, we were focusing on education and not diligently enforcing. They've had 2.5 years to adjust to the new law, and it's now time to begin enforcing more. I mean, to allow them to go for 2 years with it on the shelf, I just think it's inappropriate. I think it's piling on. I think that, the $1,000 fine for the cigarette, if we have to take that, we will. But in this case, this was an education moment on both sides, and I think it had to be much clearer than it was. And I don't think it was, and I don't think that's fair. And I think if you're going to look at the equities again, as soon as they were made aware of that, it got rid of it. And again, they had to bury a lot of money.
Does he acknowledge the July visit?
Yeah.
Yeah. Okay, so
Or August, I think it was.
August, he acknowledges that he was told at that time, no fine, no problem, but just, I want to let you know, this stuff's illegal, it shouldn't be on the shelves.
The content of that conversation was that there was going to be a change, and he took that to mean there's going to be a change in the law, meaning those products are soon going to be illegal. And he wanted to find out when that went into effect, which is why he reached out to the town. I mean, we didn't.
Are you sure it was the town, not the county?
Well.
Because I didn't receive an email.
Who's Sharon Crocker? Oh.
Okay.
I mean, we're about compliance, not punishment. Are they still on the shelf?
So, in order to vacate the mandatory fine, you would have to find that the violation didn't actually occur.
And that's, that's the struggle, because if he was given a educational warning and their interpretation of it was there's something coming down the road, and then they reached out to Health Department for a clarification, was there a response? Did you send them a response?
Yes, I contacted Bob for the regulation, and then we passed back to them that,
Them meaning them.
yes.
So they were given that there wasn't going to be a change, it was just going to be enforced. enforcement was coming, that they gave people a, you know,
Well, I didn't get into a change.
no, no,
'cause I
I'm
didn't
saying, but
understand that
I'm
part
trying
at all,
to,
but
I'm just
yeah.
trying to interpret their, you know, the legislature enacted this in
2020.
2020,
Yeah.
gave like a grace period, an educational period, get it off your shelves, get rid of the product, don't order anymore. And then,
So I got the answer
in the,
from Bob.
you know,
that
warmth of
was
their heart,
still
they gave
very
people 2 years to comply, and then they started
And then, Mr. Clerk,
inspections.
do you
Yes,
have the
sir.
leeway to just give a warning when you go in?
Well, given the situation with COVID-19, the law came into effect right before COVID arrived, and so we weren't out as much as we normally are. And at the time, out of empathy and consideration of equity and those things, we spent a lot of time educating, and these new products were coming out into the marketplace at the time in droves. And so as we struggled with how to handle it, from my perspective, it was most effective and most considerate to educate the retailers about it. We could have gone out on the first occasion and said, hey, you guys have flavored products here, boom, you're going to be fined. No, but there was at least another occasion that I recall that I went in and we discussed these things as well. At the time, over the summer, we were sort of going back and forth about how to handle the natty hemps and hemp wraps and that sort of thing. But there's no question that he had flavored rolling papers and those sorts of things that are apparent or, violations of the flavor enhancer portion of the state law. And we talked about that, and he was cooperative and took everything down. And it should also be noted that all of the other retailers that I advised to take the stuff, to put it away, they did. They took it down, got rid of it, and it hasn't been displayed again. In this case, it was. And, they weren't willing to take it down again the second time when we went in and said, we already had this discussion a few months ago, and here it is, it's all back again. There wasn't a new law coming. It was just that we were saying the law is going to be enforced moving forward. Here's your chance to comply. Hope you guys understand.
Is there a specific date that you mentioned that grace period is ending?
Well, it was after we did that, we did a whole round of, educational visits over the first several months of the year and through the summer, actually, July and August, September, and then we started going back to places that we knew we had found some violations but didn't necessarily act on them. So, and again, all of the other retailers that had these products that were advised to remove them did so.
And again, we're about compliance, not
Yeah.
about punishment.
Right.
And I think that's what Bob was
Sorry.
trying to get at.
Okay, thank you for that.
Which is why he reached out. I mean, I think it's a legitimate belief on his part.
He reached out, and then they
reached out.
responded with the law,
Well, yeah, they sent us a 69-page flyer.
which is the
and-
law.
And a very
And it-
unclear, I'm sorry?
Which is the description of the law to understand it.
Yeah, somewhere in there.
And
then-
after already being told by the person that, yes, this interpretation of this material, these rolling papers, adds flavor to it, according to the law, it's illegal. So you need to get rid of it.
The response that he got back was not clear, and you're right, there was no date given as to when enforcement was going. That's why I think it's legitimate that he thought there was going to be an amendment, and he looked out for where that was coming from and when it was going to happen. That's why he reached out. Why would he reach out? I mean, if he had those on the shelf, I just think it's an innocent mistake.
So I'll just clarify, for the employee who didn't take anything down, he was just a regular employee. I don't think he thought he had the power to do that on his own. He let us know, and after that, we've taken everything off the shelf. And also for the the hemp wraps, natty wraps, et cetera, those, I think the confusion came because we're still able to buy them from our distributor who, as soon as the law changed in 2020 or whenever it was, all the flavored games, tobacco products they wouldn't sell to us because obviously it's illegal. But these we were still able to buy. We can still order them right now. And I'm pretty well aware that a lot of other counties in Massachusetts still sell these products and aren't considered not allowed. So I'm not sure if this is a county interpretation of the state law or if it's a state law that a lot of counties just aren't regarding, because the hemp wraps, et cetera, are could be used for things besides tobacco.
That's a good point, that they can be used and are used to roll other herbs, including adult-use cannabis, the hemp wraps. So they can be used for tobacco, or they can be used for cannabis, the rolling of them.
So our interpretation was that this might require like a town.
Well, they meet unfortunately, they meet two different definitions. They meet the definition of a tobacco product flavor enhancer, and they meet the definition of a legal marijuana accessory. I didn't write the laws, but we've got a Chapter 94G law.
No, this is just.
And we have the 27028 law. So we have two different laws in Massachusetts. These products can be used to roll tobacco, and they can be used and are used to roll cannabis.
And how can the person doing the inspection know what the buyer is going to use them to roll?
They can't. What they rely on is the definition of tobacco product flavor enhancer, and if it's a flavored hemp wrap, it is, by definition, a tobacco product flavor enhancer. It is also, by definition, a marijuana accessory.
I think what they're explaining is why the distributor was still making it.
That's why the distributor would still sell it, because
That
it,
and the fact that nobody rolls their own cigarettes anymore. They
Some do.
roll
Some do.
pot, but they don't roll.
It's cheaper. Way cheaper.
All right, so I think.
Are all
go
the
ahead.
products off the shelves?
Yeah, we don't have anything off the shelf. It's all
All
off
right,
the shelf.
I'm gonna,
That's the most important thing.
Yeah, no one took.
going
We
forward.
can,
I want
we can't get any
to
refunds.
bifurcate this into two separate issues. I'm going to entertain a motion for the first violation, the product on the shelf, that a violation did not occur. And I would entertain a motion and a second that a violation was found not to have occurred on 12/28/22.
So moved.
Second.
All those in favor?
Aye.
If you've been found innocent of that, you can appeal, obviously, or I don't know if they do or whatever. On the second item, the selling to a minor, you accept then I would entertain a motion to assess the fine of $1,000 and a one-day suspension, Christmas Day, 2023. I'd entertain that motion.
So moved.
Motion is second. All those in favor?
Aye.
Aye, that's unanimous. Thank you for your time, appreciate it. Second, next item, West Main Gas, Eli Norm, 577 West Main Street. Hyannis, two different violations, 1228 and 109.
Hi, how you guys doing? My name is Eli from West Main Gas. For the underage, we'll take the fine and for Christmas Day, if that's possible.
Okay.
And then, so for the flavored tobacco, what had happened was I actually went out of the country a few days prior to the inspection. I was baptizing my son overseas, and our vendor had sent us a mispick by accident, and we had had a friend of the family who works in New Hampshire come down to cover, and fill in for us. And in New Hampshire, the laws are different, so he didn't realize that he couldn't put it up. When they did put it up, I believe he came in the first time, and they told him, you can't do that. I had told them, when they let me know, I told them that, hey, please just put it in one of the cabinets. When I return, I will talk to the vendor so I can get a refund. And then on the second time, and then overnight, I guess, when they were restocking the shelves, he wasn't paying attention. He saw that it was empty. He restocked it up, and then that's when they came back and, issued me the thing or whatever. So and then once I was aware of the second time, I told him just throw it away and, don't worry about it. I've been in business for over 20 years in that location. This is honestly the first violations we've had in 20 years, and we try to we run a clean ship. Everything is, tip top. If they want to come and check, see what else we got, they're more than welcome.
Okay. Bob, you want to just talk about the first violation?
First violation, yes, sir.
Product on the
Yep,
shelf.
product on the shelf. So, as was the case with the previous retailer, we also conducted a retail inspection of this establishment during the summer, I believe in August, and found some flavored products, which I discussed with the manager or owner at the time.
When you say flavored, same thing, it was the flavored papers?
No, these are cigarillos.
Oh, okay.
Cigarillos. So at the time, one of them was a somewhat new product that has come on the market called Dutch Gold Fusion, which is a distinctive chocolate aroma to it, if you open it and smell it. and I believe we actually did that, opened it and smelled it, and agreed that it was a flavored product. And then Game Blue, which has long been known to be a vanilla-flavored product, was on the shelves as well. So when it came back in December, these same products were there after I advised him that they were flavored. And again, in an effort to educate the retailer, advised him to remove those products from the shelf to avoid further.
And this was when?
Over the summer, August.
August again?
Yeah.
Okay.
To avoid any future violations. So I was more than surprised when I showed up in December to conduct a follow-up inspection, and the same things were there. So at that point, I reported it to the board as is my duty, and here we are.
So you're saying that in August, when he came in, you removed it and then put it away and stored it, waiting for a credit from the buyer? And then you were out of state, someone working at your store thought, oh, I'll put it back, fill the shelves?
Yeah, exactly. To be honest with you, I don't really recall seeing him in August, but I mean, I'm going to take his
Yeah, it was another person, a
Yeah,
gentleman.
so I wasn't there. I didn't have the conversation with him, and I'm the owner of the place. So, like I said, it was a mistake, and we had a friend of the family from another location that in New Hampshire. He came down, it happened with him, and now he's gone. He's, back up in New Hampshire, and he's seen that we're back and stuff. Like I said, we've been in business for over 20 years. We've complied with everything. It's not like I'm trying to, sneak anything away. If I was trying to, sell them in secret, I wouldn't put them up on the shelf. I'm not, not that dumb. I apologize.
Okay, and on the second violation, is there a particular day?
For the Christmas, for the
1-day suspension?
Yeah, Christmas Day, if that's possible.
Sure.
Please, thank you.
Okay, I'm going to bifurcate these two also and address them each separately. Understanding the mix-up, I'm going to entertain a motion that a violation did not occur on 12/28/22.
So moved.
Second.
I have a motion, a second. All those in favor? Okay.
Thank you.
On the second, the selling to a minor, I'm going to assess the $1,000 minimum state legislature mandated fine and suspend their tobacco license for 12/25/23.
So moved. Second.
I have a motion, a second. All those in favor?
Aye.
Thank you.
Thank you very much, guys. I appreciate your help.
Last is the two violations, Hyannis Package Store, 775 Main Street, Hyannis, on 11/2/21 and 1/9/23. Bob, if you could fill us in on those?
Yeah, so on January 9th of 2023, an 18-year-old youth entered the Hyannis Package Store at 1:14 p.m. and successfully purchased a single black and mild cigarillo for $1.30. The product was sold by an older adult male.
In the 8/2/21 violation? What was that for?
I don't know if I have that one before me, but it's...
Well, that case was already heard back then, correct?
That case, yeah, so that's already been heard and closed.
By this board, it was already heard.
From 2021, so...
Okay, so
Yeah.
on our agenda, it shows it as two violations. Isn't,
Oh, just,
36-month period that they have.
oh,
just to let you know that it occurred before.
okay, all right.
So it's a second
So this
violation.
is the second violation, which is a state mandated minimum $2,000 fine.
Right.
Okay. And is there a particular, I'm sorry, go ahead.
For that second violation was for the sale of flavored product. It was not for the sale. My name is Kyle Vieira, by the way. I'm counsel for Hyannis Package. So that wasn't the sale to an underage. So it's a separate violation, a different violation. And before we get underway, I represent a lot of clients in this. And from my understanding, the sale to an underage individual is only a mandated $1,000 fine. And other boards in other towns have only done a $1,000 fine. This is the first time I'm hearing, and I'm glad that we have a state attorney here, because I'd like to know what regulation is the mandated suspension.
It's the CMR. It's confusing to find because it's not under violation. It's right above the violation section. And if you read it, it clearly states.
So it's not a
that-
violation, it's a separate section.
It's a
Okay.
violation, but it was drafted improperly.
Poorly.
It was drafted poorly, and it was put right above, which is why it took some time to find it,
Right.
quite frankly. And I think I have it
Yeah,
here.
the 105-665?
Yeah.
I know what you're talking about, okay. And given that this second violation is, it's not for, we haven't sold to underage individuals twice. just once. I think that in this situation, and I will point out that there was an 8-2 violation, and that's August, where all these other individuals were getting warnings and told to pull stuff off the shelf, and my client was told that he's getting a fine and a violation. So it is a little confusing to me why other stores in the area are just getting warnings, and my client's first violation is the first time, is on this, around the same time as all these other
I
inspections.
think they were both for, this was for a sale to someone under 21.
Really? We have a notice for, he has the, he put the notice on your phone? Yeah.
Here's the inspection report. If you-
January, yeah.
No, I'm talking that's for the second one.
Yeah, the first one might have been another one, but there's no mandatory suspension for that one.
The first one was a year and a half prior, not just the
I'm
previous
just
summer.
saying that inspection, everyone else got warnings and was told, you gotta pull this off the shelf, and when they went in to inspect him, he got a violation when all these other individuals that we just heard, August 21, were punished with nothing, just told to take it off the shelves.
But I
I'm
believe
sorry.
he was referring to August of 2022 versus 21.
Oh, 21.
Yeah, this notice for this violation says 8/2/21.
Your summer one.
Right, and I don't know that I found anything in this past August. Their violation was in 21, so, yeah.
All that aside, I'm just requesting,
Yeah.
they impose a $1,000 fine, and he closes on Christmas Day for this specific violation, given that the board has already adjudicated the 8/2/21 violation a year and a half ago.
So the question before us is, was this a second violation within 36 months under the statute? And is that a mandate?
The way the law reads, a second violation is a $2,000 fine, and I believe this is.
Doesn't matter if it's sale to a minor or
Doesn't matter.
flavored tobacco on the outside?
And a suspension from between 0 to 7 days is what the state law reads. I don't know what Barnstable's reg reads
When was that law passed?
For a second violation, right?
for a second violation.
When was the law passed?
The law was passed in the effective date was 2019. November of 2019 for the vaping part, and June of 2020 for the combustible part of the law.
But the $1,000 fine is new to us, and we've had these well before now.
No, the $1,000 fine went into effect November of 2019 for violations of the state law.
This board has levied some during the last hearings that we had. And it's important to note that some of these, at least a couple of these retailers that were here for a so-called first offense today was actually a second or third that were never heard. So some of these are repeat violators, but have only been punished for one violation. But that's neither here nor there. But the point is the board has levied $1,000 fines in previous hearings.
I'm looking confused, too, so it's not just me.
Well, yeah, I was confused about your statement that some were not fined.
Yeah. So,
That came to this board or
Yeah.
did not come? Oh, okay.
yeah, that we're here today, so. But,
I don't think we should treat him any different than we
Oh,
treated
the previous two cases you're referring to.
no, I'll talk to you afterwards.
Okay.
Because it doesn't matter. They weren't heard at the time, so it doesn't matter, yeah.
So just to clarify, what's before us is that on 8/2/21, what was the violation? Just for clarity.
Mr. Chair, I don't have it before me, so I'm just
Do you
here
have
for the most recent one.
Do you know what your client's violation was?
It was sale of flavor enhancers is what the notice. He has a picture on his phone. I didn't think we needed to get into the particular.
On 8/21.
8/2/21.
8/2/21.
So it would have been for, selling products that were illegal, flavor enhancers.
Right, and that was a lot of clarification on what is and what isn't, sort of like that.
Right, and that only came after, some education as well at a previous visit.
Okay. I'm sorry, I don't have a stomach for giving someone a $2,000 fine. I just can't. I'm sorry.
To be honest, we don't have anything from either the Board of Health or from the tobacco people saying that the 8/2/21.
Right, so I don't have anything in here,
So I think we should just deal with the 1/9/23 one.
Okay.
I don't believe it.
Okay.
We're not disputing the 1.9. We'll Christmas.
Okay, so I just have to figure out how to motion this, because eventually some of this may come back on me, or us as a board in the
It's
town.
like the bifurcate.
So, yeah, I think
The way,
we have to,
the same way you've done all the rest.
I can't because it's different. It was already found to be a violation. The others were first time before us, so
We don't actually have evidence.
it was issued as a violation for
Not
21.
that they can tell us.
It's,
How many
it's
months
there.
is that?
I don't want to get into a
Okay.
ding match. So I'm just trying to figure out how to not do a $2,000 fine.
24. 28 months.
Hold on, I might have.
That noise. Oops.
Someone's phone, something. I know it's like asking the prosecutor to help the judge, but what can I do here? You understand
You
our
know what
situation.
I would- I'm going to
do-
tell you what I would do.
I can't give someone a $2,000
I would just
fine.
fine them $1,000. I wouldn't even refer to the previous one because you're right, the health department can't give you any information about it.
Okay, so I can.
So I would just treat it.
I can just
just-
address the 1.923 and just pretend the other one didn't exist. Okay.
If it makes it easier, you can just do this under Chapter 70, Section 6, which is also for the sale of underage. Don't even address 105 CMR and say it's under that
Well,
statute.
That doesn't, it does, that's
No,
not
it
gonna
doesn't
matter.
really.
Okay,
Just-
so,
I would just
all
do
right,
it.
so I'm gonna entertain a motion just on the 1.923 violation, selling to a minor, to assess the state mandated legislature minimum of a $1,000 fine and a one-day suspension of the tobacco license for
1225.
12/25/23. I'd entertain that motion.
So moved.
Second.
I have a motion, and a second. All those in favor? That's unanimous. Thank you for your patience.
Thank you.
Thank you. On to the next item. This is a food variance, Blaine Tote, West End owner, 20 Scudder Avenue, Hyannis, map parcel 290-112. This is a 1.25 acre parcel using a 3,500 gallon grease trap. Currently has temporary permit for an additional 86 exterior terrace seats, which they are requesting to become permanent.
Would you mind if we set?
Certainly. Bob, can you guys take that out? We have next hearing.
Next time, sorry.
Thank you so much. They have plans and stuff they have to lay out in front of them. Sorry to kick you out.
No, thank you.
Thank you for your
If I
time.
could just close by saying, you know, I derive absolutely no joy or satisfaction.
We know, Bob,
Yeah.
you're doing good work. We appreciate you.
Thank you, I appreciate you.
That's, yeah.
No. Poor Tom, the hardest working man in Barnstable has to go to a Concom meeting, so, because serving on one volunteer board is not quite enough for him. But we still have quorum, so you can go forward. Would just introduce yourself, sign in, and then give us the rationale, please.
I'm Blaine Tote, the owner of the West End Restaurant in Hyannis.
Anthony Ponabianco, counsel for the applicant here. In sum, we're here asking for a variance from the grease trap regulations, and we had been granted previously a one-year variance for the grease trap. Currently, the grease trap at the restaurant is 3,500 gallons, and they are looking to permanently add 86 seats, which have been in place at the restaurant for nearly 4 years now since COVID started. With the COVID-19 expansions to outdoor seating, that was permitted back then, and now it's become a permanent feature of the premises. And in doing so, part of our site plan review was to go in and have, it would require an increase of the grease trap that they currently have from the 3,500 gallon to a little over 4,600 gallon with the additional 86 seats. So we're asking for a variance from that requirement so that they can maintain permanently the grease trap and continue to operate the business. The reason that we're asking for that, and we think that it's a reasonable request for this variance, is in part because they've operated for 4 years without issue with this seating capacity, with this grease trap installed. But additionally, in terms of what we've done is have increased pump outs and make sure that there are no concerns or issues there. But we also have to take in, when we're looking at the strict requirement here of an increased size of a grease trap, the cost to the business to install it would essentially make the business not be able to function and operate. And I can have Mr. Choate explain that a little bit more. But in the way that the restaurant runs is that to have all seats occupied at one time, which is really what the requirement is looking at, the 15 gallons per seat that makes up what the requirement is, that assumes that there is a full seating of all 300-plus occupancy load at that time, which doesn't happen in the restaurant. The 86 seats that are additional are for wedding events and special events of that nature that don't take in to have a full, complete seating of that nature. It's just an additional space. So for our purposes, we think that the question of the board that's always presented for you and the task that you have is to ensure the health and viability of the citizens here in Barnstable will be met by the continued use of the 3,500-gallon grease trap that has been in use with this occupancy load essentially for 4 years without issue, without concern. And rather than having to punish a restaurant that couldn't operate in that way financially if required to come into strict compliance, rather we ask for this variance to become permanent.
Okay, thank you for that. This is a public hearing. If there's any members of the public that would like to speak on this item, please come forward. Seeing none, we'll close the public hearing. Staff report.
Staff, the health staff received the variance request, but also received a copy of the email from the town engineer, Griffin Bowden, which reads as follows: DPW does not support this request and is of the opinion that a properly sized grease trap needs to be installed for this property. Last year, we submitted the attached letter expressing this position. At that time, the owner had indicated he planned to repave his parking lot this year, and as a result, wished to wait to do the grease trap until this year. The owner had expressed commitment in writing to install an appropriately sized grease trap this year. In an effort to work with the property owner, we supported a temporary variance for 1 year with no future extension to be considered. So he attached all the documents to his email. Does the board receive that? Okay.
Everyone received that, right? Yeah.
I did. I got a copy.
Yeah, a copy of the email from Bowden.
So if I can address that briefly?
Sure.
And so I spoke with him on that particular issue, trying to think of creative ways to appease the DPW to ensure that they would be satisfied with the conditions of the restaurant and the grease trap. Part of that is you look at the menu; it is not a heavily grease. It's not a fast food, frying a lot of food restaurant. So the quantity of grease oils used in the restaurant is very different from some other restaurants that you might have that necessitate a very large grease trap. And again, the capacity seating that we talked about, and I went through that with Griffin last week just to discuss options. And while we understand their concerns, we do think in this particular instance, granting a variance, a permanent variance, allows the restaurant to be permanent. And the concerns that is written into the bylaws and that the Board of Health is charged with, I think are supplied by the restaurant, and in the terms of willing to make a commitment to the town, willing to make a commitment to provide the pumping that is necessary, and make a showing that the regulation that's required that we're asking a variance from shouldn't apply in this particular instance because of the full nature of the business. It doesn't need the 5,000-gallon tank that would be required under the bylaw.
I forgot to include that the Board of Health already had a hearing on this and voted not to grant the variance. I'll pass this down to, this was previously, in the minutes from, I have a copy here that I wanted to pass down to the chairman.
What's the date?
What's the date of that?
Sharon will have to look that up for you.
Now that we have this, I don't have access to the internet. Wasn't in any of these, huh?
I believe it was sometime around March of 2022, but we can get that verified in the records.
I have a letter here from Griffin, copy in the package that we got from Griffin Bowden, written, sent Tuesday, March 15th, 2022. It was sent to Blaine.
It's me.
And it's, thanks for the clarification. Given your express commitment to install a properly sized grease trap next spring as part of your planned parking lot improvements, we would be supportive of consideration of a temporary variance for one year with the following conditions. The variance is temporary and the applicant is required to attend the February 2023 Board of Health hearing to report on the status and schedule of grease trap replacement. During the temporary variance, the applicant shall pump the grease trap every other month between the months of May and October. The variance expires after 1 year and no future extension is considered. If the grease trap is not replaced with a properly sized grease trap, minimum of 5,000 gallons prior to next season, the total seat count is restricted to 233, the maximum amount of seats that can be supported by the existing 3,500-gallon grease trap. So that's...
If you recall, we had a number of hearings last year. Alberto's, for example, was denied. West End was denied.
Yeah, I mean, the board's position has been pretty clear. The reason why grease tanks are under our purview is because it's typically an on-site septic system. So they're not tied into town sewer. Our position has always been, we shouldn't even be in this discussion when it's on town sewer, because it's DPW's purview. They're the ones trying to prevent grease from getting in their sewer system. If we're looking at it as an on-site septic system, it's because we're trying to prevent the septic system from failing prematurely because an overabundance of grease is getting into the leach field and clogging it. If an overabundance of grease gets through the grease tank and gets into the sewer system, it's going to clog a sewer system, which affects hundreds of people, homes, if there's a clog and sewer's not, flowing properly. So it has always been the position of this board to defer to DPW when it comes to sewer and the size of grease tanks. I understand, many arguments have been made before us of, the likelihood of being at full capacity. That's not the way design standards are, and you're probably aware of that. I mean, if you have a 4-bedroom design of a septic system, they look at the house as being fully occupied when it comes to the design. If you're building a football stadium, they look at the fact that what if 60,000 people all of a sudden flush the toilets at once? That's the design criteria is always the maximum, and it's usually unreasonable, but you have to have a standard somewhere and it's set. What I'd like you to speak to just a little bit, just for my own edification, is you're saying that it's not financially viable to go from a 3,500 to a 5,000-gallon tank. And having been in the business and removed tanks and replaced them with bigger tanks and tied them into sewer systems, I just want to know what kind of quotes are you getting that's making it financially unpalatable that you won't survive as a business if you have to be required to make that upgrade to get the additional seats you want. It's not like we're imposing this on what's existing. It's you're looking for the additional seats and not the additional size tank to support those seats.
Well, yeah, I mean, I could probably spend a couple hours talking to you about the expenses that go into running a business, and some of them might be, common sense, and the other ones might be like, oh, wow, I didn't realize that, those were so impactful.
I think specifically what I'm looking for is if you get those additional seats, that's additional revenue. And it's additional revenue if they're occupied, it's not
Right.
additional revenue if they're not occupied, and
Right.
I understand that.
Yeah.
But unfortunately, using design criteria, we have to go by the assumption that perhaps you sell this restaurant a year from now, and the new owner does something different, and they're packed every night. It's a great, everyone wants to be there, and they're packed. And we've got a sewer system that's potentially, the grease is overflowing into, solidifying and clogging the system. So again, that's why I defer to DPW and how
Sure,
they
yeah.
want to do these things. But I'm just curious, like, what kind of quotes are you getting that's so unmanageable to remove the 3,500 and put a 5,000? It's only, I think, 2.5 feet longer and 2.5 feet wider. It's not,
Yeah, I'm not sure the difference in the size, why it would be more. But the people that I spoke with, I did have Robert Auer come by and another local company, and both quotes, we didn't get official written quotes. It was sort of, tire kicking, because I was thinking the same thing as you, like, how much is this going to cost us? Is this going to cost us $10,000, $15,000, and that's something that we can probably, afford to pay for? Or is this something 25, north of 25, that's going to be a big impact, a capital expense, which when I'm looking at the budget for the restaurant, I have my operating expenses, I have my budget, and I have my forecast for the year that I'm in. And then the next year, I'll be looking at capital improvements. Was when I spoke with Griffin last year. I said that we would put this into capital for 2023, with the assumption that we would have a successful season financially, which we didn't. But that's not anyone's problem necessarily, except for mine. But the other piece of information that kind of filtered into our decision to not move forward with the grease trap in the parking lot was because there's a project happening at 35 Scudder Ave, which I'm sure all of you are very familiar with, the Twin Brooks development. And if that does get greenlit, our parking curb cuts will be altered, and we'll be in for basically a new parking lot anyways. We'll have to address that when that happens. So that whole part of ripping up our parking lot, putting in a new grease trap that's going to satisfy the DPW from a gallon perspective based on the capacity that we're applying for, and then to redo the parking lot again shortly down the road, seemed like, I thought, with the pump records being, last year almost being a little bit of, are they actually going to pump the grease trap like they say they're going to? Because it's easy to not do that. No one's checking on our grease trap records, our pump records. And for most restaurants, no one's saying, hey, when's the last time you pumped your grease trap? So relative of the size of the grease trap, if it's 5,000 gallons or 1,000 gallons, if you don't pump it, you have the same problem. So pumping is really the most important part of a grease trap, not the size of it. It's not like a 5,000 gallon grease trap is going to stop us from ruining the sewer system. I could just not pump it, and that would still ruin the sewer system if it was
Well,
any size.
The design criteria is based on cooling and the distance and the mixture, where the hot water, because typically the grease is generated from dishwashers,
Yep.
washing pots and pans, washing greasy plates, whatever.
Yep.
And it's warmed up, it's heated to go through the dishwasher, gets into the septic system. The tank is a cooling mechanism. It cools it so that by the time it goes from the inlet to the outlet, it travels that distance and that gallonage, dilutes it enough to where it separates. The grease floats to the top, solidifies.
Good
the
water
tea,
goes into the
baffle
septic.
prevents it from flowing. Only the water goes out. As the grease builds up, yes, it can get out there, but it's a lot more likely to get out there if it hasn't solidified yet. And I know dealing with on-site septic systems, we've opened up leach fields, and there's been grease in the leach field, because even though the tank was sized sufficiently, it was a breakfast restaurant that did a huge volume, and it was just that they couldn't get the grease to cool quick enough. Long story, they ended up having to put a cooler in to lower the temperature before it entered the tank so that it could hide and solidify. So that's the theory behind that, and that's the basis of it. It's, yes, you can pump it as much as you want, but if you're doing a high volume and running a lot of material going through there, there is potential for grease to get beyond the tank, even with the tea on it, if it's really churned up and mixed into a hot liquid tank.
So would there be, to that point, just made me think of something. I'm like, how many sinks would it require, of grease going down for that to actually take place in the size of a 3,500 gallon tank? Would I have to have multiple dishwashers? Would multiple drains needed to be used? Because we have one dishwasher. I'm just thinking of the likelihood of that happening.
The engineering discussion of, like, this is why it's designed this way.
Yeah.
And we have an engineer willing to come forward and tell us, why.
All right.
Dan Ojala.
Idea, not because I'm in a hurry, but what about just adding a 1,500 in series? We've had good luck in the past of adding a tank in series. It'd be less money, and you'd still get your 5,000 gallons. So
That was
just
going to be
If Griffin allowed it,
That was
maybe
going to be
would
my next question is to, can we get a quote and see what adding, because it does.
That would be great.
They have
I
restaurants
like
that
the
have.
second in a row, too, because you get 2 bites at the apple to get
Right.
that grease out.
And
Where
it's-
is the grease trap now?
It's in the parking lot in the front of the building.
In the front?
Yeah.
So
So
it'd
it'd
be
be in
probably
the
pretty
same
easy
place.
to add one in series.
Because there are restaurants in town that have tanks in series. They increase their flow, and they came to us and said, because of physical constraints, I can't put a big enough tank here, but I can put 2 small tanks in tandem.
Yeah, we're saving
So-
the environment, too. We're not wasting that 3,500. It can still be used, so.
Right,
yeah.
right.
Just a point of information, it was February 22nd, Board of Health, meeting, just
Yeah.
last year.
No, the scenario is that, we were granting an extension because the thought process was down the road and the
Right.
capital expense, something like that.
How about suggest they go back to the DPW with that idea?
And again, we like to
If
defer
that
to the
works
sewer,
for you.
so
Yeah.
why don't we continue this for 30 days?
Yes.
Go to Griffin, DPW, and say to them, how about if we put a 1,500-gallon tank, get some quotes, get companies to come out and specifically give you a quote? Because if you come back to us and say, here's the amount of money I have to spend, you may not even have to come back to us. You may just look at the expense and say, I can do this. Go pull a permit, get it done, and
I would prefer to do that.
they'll sign off on it, and you won't have to come back before us. Because it seems like that's a viable option, and if you can financially take that, it will meet the criteria if if the engineering department, DPW says it will. Because again, it's their sewer system. They're not going to call us to undo a clog. It's them, so I really, really like to defer to their druthers on this, and they're saying they don't want us to grant the extra seats without the additional grease capacity.
So how about we grant the continuance for 30 days?
Yeah, that's what I'm saying. We'll continue this for 30 days. Come back to us if you have to, but in the meanwhile, get a quote, talk to DPW, see if you add just a 1,500 to the 3,500, that gets you your 5,000, and that'll get your additional seats that you can come back to us and have us sign off on.
So that's fine. I just wanted to address your concern there. Our current one-year variance goes through June 8th, I believe, of 2023, so we're still in compliance right now, just,
Yeah.
Yeah. So, all right, we'll continue.
What were you saying about reduction in number of seats if the village is going to be built behind it's probably going to destroy the whole West End Rotary. I don't know how they're going to handle.
Yeah, I'm not sure on that either.
It's impossible.
Yeah.
But everything seems impossible now, what's going on, but.
Well, I could.
And how much reduction would that give you? Your parking would be decreased, right?
Well, it can't be decreased. We're already deficient. We've got a parking agreement.
Take away any of your land, do you own right out to the street?
Well, we lease the property. Yeah, we just own the business.
So they might not own all the way out to the street.
They own out to the street, but if the curb cuts change, it'll change the availability of parking, the flow of parking, which is what we anticipate.
right.
And there might be a crosswalk there.
Yeah, that's not a Board of Health issue.
No, but we're just answering.
There's
Just answering.
yeah.
Just giving some information.
Okay. So if that's fine with you, we'll entertain a motion to, I would entertain a motion to continue this for 30 days until they get some additional information. I have a motion.
So moved.
I have a motion and a second. All those in favor?
Aye.
So let us know how you make out.
Thank you, Board.
Thank you so much. The next item on the agenda is a show cause hearing, Stable. Janet Woodbury, owner, Stable at 365 Sampson's Mill Road, Katuitt, operating without a current stable permit.
Nobody here.
Anybody here for that?
Looks like the person is not here, and the reason for the hearing, if you want to I can tell you the reason, otherwise, or you can continue, or you can just drop the case.
Did they get the permitting compliance?
Yes, they finally did, and after being notified 4 times by email and then 4.
Okay, but as of today, they have a permit.
Right, and the whole reason for this hearing was not just to drop the case, was to prevent it from rehappening next year. They have to renew their horse stable permit every year. We don't want to have to go through all this every year.
Okay.
I mean,
Say a
the health
prayer.
inspector had to keep going back and leaving our business card and getting no action,
Okay. Well,
so.
then,
Well, can you send a letter, or?
they sent everything. They dropped off, they taped business cards to the
Yeah.
Well, continue
properties
the
and stuff.
hearing for a month.
Well, no, they have a permit now, so.
Right, but I mean,
So I'm not going to waste time coming in to just lecture somebody. So we'll just
See how it goes.
see what it goes next year, and if they come before us, we'll remember, and you'll remind us.
Okay.
You'll say this was,
bring this-
remember that?
We'll bring the file.
So I would just motion to withdraw the show cause hearing then, if they have the current permit. I have a motion?
Second.
I have a motion, a second, to withdraw. All those in favor?
Aye.
That's unanimous. Next item, a variance septic, Dan Ojala, Down Cape Engineering, representing Donald McKinnon, trustee, MCM Realty Trust, owner of 910 Main Street, Katuitt, map parcel 035-090. This is a .7 acre parcel. This is the repair of a septic system requesting multiple variances with the Nitro E denitrification system. Good afternoon.
Good evening, Chairman Norman, members of the board.
Thank you for your patience. Had I known the tobacco thing was going to turn into this hour-long, I would have bumped you up. I really try not to have paid consultants and engineers sitting for hours at a time. We try and think of the homeowner, so I apologize. I thought I was going to get through that quicker than I could, and unfortunately, we
Understood, and
opened
your
up a
health
can of
director, to
worms.
his credit, did tell me not to come in until 4 o'clock, so that saved an hour of billable time, but no problem at all. Let me hand out real quick a slight revision. The staff had just a couple typos caught on the plan, but just so you have the latest one.
Thank you.
Thank you.
Sir.
This is repair of a failed system, so you could possibly expedite this as well.
Yeah, I'll be very brief. Repair of it, 4-bedroom to 4-bedroom. It's actually better than the last time you granted all the variances on this, because before, we weren't going to do a pump chamber, and so we respectfully asked for a variance for the leaching to a state bank. DJ would like to put in a little workshop, and so he's decided to go ahead and bite the bullet, put in the pump chamber and pump it up, but that gets it much further from the bay, and so the only variance that we need is from a sealed tank to a state coastal bank, which is a dry resource area, and it's 76 feet away from the pump chamber, so very safe situation. And I would make the judicial note that he's putting in one of these new nitro systems, which is the latest mousetrap for removing nitrogen, very sensitive to the environment. His brother down below has one that's pumped up with a nitro, and he's got this one under contract. We did provide the O&M for that. And so again, it's very similar to variances you've granted in the past. We just slid the leaching even further from the wetland, and we're trading the variance from the getting rid of the variance to the leaching and having one for pump chamber. So quiet little workshop. The only thing I would add on this, and I forgot to add to the plan, but DJ just asked us late if he could have a convenience bathroom in his exterior workshop. And Tom, we usually allow those, you know. So with your permission, we'll revise it again just to show a little sewer line and water line for the workshop.
There's no limit on bathrooms. Did you bring the floor plans with you as well?
We'll get those to you in a day or two, but it's just a very simple little tiny shop. I think it's the 2 rooms maybe and a little climb-up loft. It's not a bedroom, nothing like that, just a little bit of, get out of the house space. So we'll provide those if you would be so kind as to approve it contingent upon staff review of the.
On the floor plans, you only had 3 bedrooms. The fourth one, that room down on the first floor that could be used as a bedroom,
It's been 4 bedrooms all along.
so that's the one?
Yep.
Yeah,
been 4 bedrooms all
I think that would qualify, yeah.
Yeah, down on the right, left-hand side of the house.
Yep.
A year ago, you didn't have the plans for the pump chamber. I wasn't, whatever, I wasn't on the board then.
Okay.
But this is a much a much better septic system.
I like it. It pumps it further away from the bank, you know, it's almost as far as you could possibly be on the lot, so I think it's a good change.
Bleaching facility, that's H20,
It is, yep, yep.
but not the pump chamber.
No,
That's not in the parking?
we did actually throw H20 on that. It's not under it, but it's close enough, so we'd want an H20, yeah.
It says H20 on it.
Yeah, on the upper right, I think it does call out H20, yeah. The tank is H10, but the pump chamber is H20, to your point.
Right.
This is a public hearing. If there's any members of the public who would like to speak on this, please come forward. Yep, come on. Stand at the mic, just sign in, and then just make sure you turn the mic on so it's green, solid green light.
Kathy Bunting, and I'm the abutter to this property, so I've been paying a lot of attention to it. When the variance was first approved for the multiple properties, I was under the impression that there would be no further buildings, and I think that's one of the reasons he got the variance in the first place. So I'd like to clarify that for one thing. The other thing is just the size of the two homes that were there prior to this project. Both have almost doubled in size, and I know the nitro septic systems are a big deal, and we're all pushing to go that direction, but I do think as far as expanding the size of the overall project, this will be the third building on that lot. The lot lines have changed multiple times, and I just think between conservation and you, I'm new at this, trying to figure out what direction to go to as far as controlling a project that has ballooned into scope, and we'd like some clarification as far as how the variance was approved the first time, and here we are again approving a workshop, and now I just heard today, which is not on any plans that and I have a stack of paperwork, a convenience bathroom. So I would just ask, how many bathrooms have we gone to from the beginning to the?
Just so you know, the purview of us is the septic system.
Right.
Size of the building, that's not our purview. It's as of right. If he's doing something that's not as of right, then the zoning board would catch it, or the building department would catch it when he goes through the building permit process. You can have a home that's a 3-bedroom home and have 16 bathrooms. Bathrooms count is irrelevant. It has nothing to do with the Board of Health also. It's the bedrooms that we focus on, and the number of bedrooms equates to the gallonage, and the location of this property would be what we would consider nitrogen sensitive. And so typically, we would push them towards a denitrification system, which they've done. It would not be mandated. It would just be, we would probably say, hey, you're really close to the water here. We would really, before we would grant these variances, want to see a denitrification system. But I understand your concerns about size of building and number of bathrooms and things like that.
Well, so
That's
number
really,
of bathrooms, number of bedrooms.
that's not our purview. Now, you
okay.
can build a 4-bedroom home with 16 bathrooms. It doesn't affect the flow. As far as the DEP design criteria is, they go by the number of bedrooms. If he came to us with more bedrooms than he had previously, and, Dr. Cuniff had said, wasn't it 3 previously? No, it was 4 previously, but that's what our purview is the number of bedrooms, the groundwater impacts, the health impacts, things like that, size of building, scope, how they design it, that's all as of right, unless the building department tells them you're too tall, you're too wide, you're encroaching on your setbacks, for your property would be the same concerns. If the setback is 15 feet, you can build to 15.1, side to side. If the front setbacks are 10 feet, you can build 10.1 right to the front. So size is really not our purview.
So the variance, though, that was granted in order to get the projects approved was based on no further building on the property?
Just the septic size. The building's not our
I think you're mistaken on that point. I would say, Dan from Downcape Engineering, we made no representation that would never, ever change anything else on the site. In fact, there was no additional, bedrooms than was existing before.
No, it was a 3-bedroom house when DJ purchased it.
It's a 4-bedroom leaching field, and plus, it's not in a nitrogen-sensitive area anyway, so the number of bedrooms is only limited by what you can squeeze onto the lot. And even with the current changes, all you have to do is put in an IA, and we're putting in the top-of-the-line best IA that there is. So there really wouldn't be a limit on the number of bedrooms. But that being said, we're being very reasonable in keeping it to a 4-bedroom design flow. So it fully meets all the requirements. It's wholly within his rights as a homeowner. And hopefully this board will see where we took the leaching, which they gave a variance to the coastal bank and moved it away, so we don't even need that variance anymore, that this is probably a superior plan to what we presented last time.
So the additional building, that was never on any prior plans.
It's a little
but to get the
garage.
variance, you had said that no additional expansion to the project was going to take place. That was definitely clear in the first presentation.
Maybe it was the zoning board of,
I don't think we've ever made that.
I don't.
We wouldn't even ask that question. It's not in our purview. Like, they can build as many buildings on the property as they can
But to
fit
get- to
as of
get
right, as long as they don't have as long as they meet the criteria for the septic. And the reason why you were giving notice as an abutter is because of the variances that are requested. If you have a specific argument that these variants would somehow adversely impact you if we granted them, those are the things we want to hear about. Whether you don't like the size of his building or the number of bathrooms he has or anything like that, it's not our purview. We're just here straightforward for the septic system and the environmental impact of that, and the variances that are being requested are minimal, but if you have impact that you'd like to let us know the variance on one of these would impact you, we'll absolutely listen to that. But as far as like, well, before you, like, we wouldn't even ask that question. If they came to us in 2022 with a plan that did not show a garage, and then they came back to us in 2023 that showed a garage, doesn't matter to us, because that's not our purview.
Well, I'll talk to the conservation
Yeah.
board then.
Yeah,
Conservation would have a say in that, not
On
us.
33 Oyster, which is perhaps even more sensitive and is down near the water, that, you might have heard something to that effect on that one. I don't recall, but that one certainly, we moved the leaching much further from where it was. And, there's not cesspools as on adjoining properties. It's all state-of-the-art Title V with the best IA available.
According to the records, for the benefit of everyone, a year ago, you were granted 2 variances from this board.
Yeah.
And now you're only asking for 1 variance.
So it's a reduction.
Reduction of variances as well.
Yeah.
If anybody wants to see the letter from last year.
Yeah, that's accurate.
Okay. Anyone else from the public like to speak on this item? Seeing none, I close the public hearing. Staff?
Well, staff had no objections, but we had a list of about 8 items, which we contacted Mr. Ojala, and it looks like he made most of the corrections. We're still awaiting just the floor plans on the proposed workshop. Correct. But I believe he made all the other corrections to the plans that we asked for. I've been going through them.
Can you quickly tell
They
us
were, they were to show a reserve area, which he now shows at the SAS, to show the test hole data for number 5 and number 6, which he shows, to show a vent pipe for the SAS, which is underneath the driveway, which he now shows the vent pipe, to show us the type of pump that's being used, and you already, Dr. Gann, talked about that earlier, about the pump chamber that's shown on the plan.
Myers, yeah.
There is a question about a box. Is it a well? You can see there's a box that's called proposed storage box, and looks like a water line comes from it. Is that a well?
So no, all that is just so you can rinse your hands or feet down by the water. So it's like a recreational, water dependent.
It's a rinsing
Just like a
area.
spigot, yeah.
Okay. Is there anything I missed, Dan?
No, I think Craig got everything, well, the floor plans you said you were waiting on, and if we could hopefully have staff approve that, but it's just a modest little workshop with a...
Unfinished, unheated?
Yeah. Well, the workshop is going to end up being, would like to have a little convenience bathroom in there, so we'll probably put a little Renai heater or whatever that is in there. And I'll revise this plan again just to show the water line and the septic line to that.
I mean, it won't appear to be used for sleeping?
Absolutely not. Yeah, 100% no.
Okay.
We've got 4 bedrooms in the main house. That's all we need. Yeah, no.
Okay, thank you for that, staff. Members of the board, any comments or questions from anybody? No? I would entertain a motion to grant the variance as requested.
Second?
I have a motion and a second. All those in favor? Aye. That's unanimous. Thank you very much for your patience and your time.
No problem at all. We
Latest
completely
plans
understand.
back.
Yeah, why not?
The next step,
Do we have a couple of copies for the office?
drop those off to Sharon. Thank you. The next item on the agenda is Robert Taylor, owner of 34 Edgewood Road, Hyannis, requesting an extension for the repair of a failed septic system on May 5th, 2021. Sewer is available in approximately 8 years. Good evening.
Evening.
I appreciate your patience. You've seen you sitting there and sitting there and sitting there.
Oh.
Sorry.
I bought my house a year and a half ago and was told at the time that new sewer was going to be done on our road within 8 years. So I'm just trying to get an extension so that I don't have to put in a septic system and in 3 years have it be obsolete. There's only one person, only one occupant. It's got 2 bedrooms. It's like I said, there's only one, one occupant. So I'm just trying to avoid having to buy a septic system and then having to, in maybe 3 or 4 years, having to hook into the sewage, which I want to hook into the town sewage.
Right. Okay.
It's pretty much that simple. That I'm trying to avoid putting in a septic system and in a few years have it be obsolete.
Alrighty, thank you for that. This is a public hearing. If there's any members of the public who'd like to speak on this, seeing none, close the public hearing. Staff?
The system I have now, it's working perfectly fine. And like I said, I keep emphasizing the fact that there's only one person,
Yep.
Okay. I received an update from the town engineer that sewer will be available the year 2030, so about 7 years from now. The staff reviewed the septic system inspection report. The concerns we have are about the cesspool. Troy Williams conducted an inspection, a private inspector, and found that that there was less than 6 inches above the invert of the cesspool, and also the crown appeared to be starting to cave in. So the concern from staff is the safety, of course. Safety always comes first. So that is our main concern. We wouldn't want someone to fall in when it collapses, if it collapses. But we do encourage people like Mr. Taylor to come forward with these types of requests. Of course, we don't want to see people spend money twice either. But this is a unique case because we're also concerned about the safety with this cesspool potentially caving in based on this report.
I'd be willing to clean it once a year.
Yeah,
Show proof of that.
Pumping's easy. We can grant you that because typically, what is it, 4 pumps in 1 year triggers
Yes.
a repair?
And like I said, I'm the only person on the property. If I know where this problem is, I won't go near that. I'm the only.
Yeah, unfortunately.
I'm a single occupant.
Unfortunately, we have to look at it from a public safety. If there was a fire and the fire people are walking in your backyard and all of a sudden they fall in a cesspool. So there are ways to, temporarily repair cesspools that are like, because they're kind of like a beehive. They stack the block, and as they get closer to the top, they bring the block in, and over time, those blocks can kind of move and shift, and sometimes, and then all of a sudden you'll get an entire side that will just collapse. So there are ways to kind of repair those that you can, make them last a few more years longer. And there's.
Well, they've just been telling me I got to put in a whole new.
No, we're not going to make you put in a whole new system if the sewer's only 7 years away. What I'm saying is that there's ways to just keep the safety. I mean, there's, you could put a, small steel plate over the area, and then that way.
I'd be willing to do anything to
Right.
fix it.
No, I'm trying to work with you. We're just looking for
I'd
suggestions.
be willing to do anything to fix it.
That's addressed in the Title V inspection when the house was bought.
Yeah.
That's why I'm asking for an extension from that.
The crown, I guess you can explain what the crown is. The crown is where it starts to come together. And so that's, like you say, the part that somebody could.
Yeah, the blocks start to deteriorate.
How about if we make a motion or consider having it inspected and repaired?
Well, that's the thing, is it's been inspected. We know that there's, the concern that the block is, the blocks is.
A couple of years ago.
Right, and so it's probably only got.
I wasn't told it could just be repaired. I was told I had got to put in a septic system.
Yeah, that's the rules, but we're here to.
If sewer wasn't coming, you would have to
I mean,
put in
Yeah,
a septic system.
if
Well,
sewer.
obviously, of course, yeah.
If
yeah.
sewer wasn't coming, this
Right,
wouldn't.
I understand,
we would-
yes.
But we're trying to work with you because we understand.
Right.
We don't want to make you spend $10,000 to put a new Title V septic system in, and then 7 years from now tell you, oh, and yeah, now you can hook up to town sewer. But to bridge that, the concern is safety. If it was just filling up and, you had to pump it twice a year, that's fine. We would grant you a waiver on that to just pump it until sewer's available.
So could you give me a length of time in order to get it repaired?
No, because it's a safety issue, and that's the concern. As I understand, when I say repair, I'm not talking about digging the whole thing up. There are solid concrete rings that are about 4 inches thick and about 6 feet wide that have an 18-inch cover that you can pop open, that you can lower down, expose the top of the cesspool, lower these down on top, and that bridges the compaction, like you could, then it's backfilled, and then someone can walk over it and not have to worry about the wall collapsing in anymore. So it's might be $1,000. It's not an expensive repair. You know what I'm saying? So I'm just thinking something like that, Tom. You've seen them do that before years ago when they used to allow repairing cesspools.
Yeah, if this board votes to allow for that sort of repair without an engineering
All right,
plan,
I'll make a motion that we allow the repair of the existing cesspool.
For safety. And you know what I'm talking about, Tom, right? You've seen those.
4 inch thick?
It's the
Yeah,
4 inch
6
thick,
feet.
it's the 6 foot diameter. It
Yep.
basically is like if you took the top of a 1,000-gallon pit and just chopped the top 4 inches off it, that's what it looks like. It has the 18-inch cover in the middle, and the installer just goes out and digs up and exposes the top of the cesspool, gets a fairly level, flat area, puts a little bit of mortar down, and it just lowers it down on top of it.
No, there's still people who can and who will do that? Oh, okay.
Yeah.
Because you just said we don't allow for it anymore.
Well, we don't allow for repair of a cesspool, but those lids are made for, like, upgrading an existing cesspool. It's used for a bunch of different things.
Okay.
And the only reason we would allow it is because the sewer is coming.
Right, and we're gonna,
temporary repair. Yeah.
we're gonna put that in the order too, is that when sewer is available, you have to hook up right away. So don't
Oh,
come
of
back to
course,
us in
yeah.
7 years and say, well, I don't have time to hook up for the sewer, I don't have the money for it, so,
Yeah.
we're gonna grant you this, but we're gonna want
That's my
something down
point.
the
I've got
road.
the money for that. I don't have the money for
Right,
both.
exactly.
I got
So-
the money to hook into the
Well,
new
you don't
storage.
want to throw
Yeah.
it away.
So we have a motion on the floor to allow for the repair, safety repair of the cesspool to bridge the time frame until sewer is available.
I think you had a motion.
You had a motion, I need a second?
Second.
I have a motion and a second. All those in favor?
Aye.
So get with Tom, office, they'll explain to you what you can need to do, and you'll need to contact like a contractor.
Right.
A septic installer, licensed septic installer, and explain to them, the board's gonna let you just make this safer by putting a new cap on top of it, and Tom will sketch up something or show you and talk to your installer, but we would like this done within the next 6 months. Okay?
So I don't know who Tom is. I mean.
Tom is the Board of Health.
Yeah.
So you gotta go into the Health Department and just, they'll explain to you,
Right.
to contact a licensed contractor.
Right.
Septic installer.
What's that, 200 Main Street?
We're at 200 Main Street. Yeah.
And
That's where you are, 200 Main Street, so I can drop in during the day and
Yes.
talk to you?
Yeah.
And I'm going to suggest you call 3 contractors, get 3 different prices for this special cover that goes over it to make it safer, without engineering plans.
And if they have any questions, call the health
What's a
director.
good day
and
to come in?
He'll explain to them
Monday through Fridays.
Oh, any day, okay.
Most afternoons, at mornings, some mornings I have meetings, so afternoons usually better. Come in before 4:30.
All right.
And as part of this order, when sewer is available, you'll be expected to hook up.
Right.
Okay?
Okay.
Thank you very much for your time.
Thank you.
The next item up on the agenda is septic system variance extension request for Captain William Murphy, owner of 104 Wild Goose Way, Centerville, map parcel 167048, requesting an extension of a variance of a 4-year variance that was given that is that would like to be extended until August of 2027. No one needs to be here for this. This, if you remember, this is a parcel that had all of the permits, approvals, anticipating retiring. The government extended his enlistment, and he's still fulfilling that obligation, so he's asking for another extension. This is just a vacant lot. All the permits are in place, and just extending those permits and the approval to what looks like a new time frame of August of 2027. Wait a minute, I have from staff, hold on.
Sorry.
Staff, do you have any additional comment on that?
Staff has no objections. Just want to pass on, Tom Lee emailed me that he will have to go back to conservation as well, which is separate.
Yeah.
And there are 4 variances. We have no objections. 2 are from the foundation and 2 are from a coastal bank.
Yeah, and if you want to include in that response to Captain Murphy, just let him, make him aware that conservation will also need an extension too.
And thank him for his service.
And thank him for his service. Now I'll entertain a motion.
So moved.
Second?
Second.
I have a motion and a second to extend the deadline to August of 2027. All those in favor? That's unanimous.
I want to thank Mr. Starr, our council representative, for coming to our meetings. It's, very nice of him.
No, we're not done yet, unfortunately. Regulation and policies. This is a request from the Director of Public Health to approve temporary holding tanks at locations where public sewer will be provided in near future, within 2 or 3 years. Staff?
I have no objections.
Just-
I mean, the problem is DEP would object to this if it's a holding tank that's going to be used for new construction or for a new house. Tom Lee reached out to DEP and received that response that they do not allow holding tanks for that purpose. But I see it differently. This would be a temporary holding tank in areas where sewer is coming within 2 or 3 years. We have 2 cases. One is at 900 Finney's Lane, for example. If you've seen, the trees are cleared out at the corner of Longview Drive. He just wants to get his building permit to build his house, and doesn't want to put it.
Down in the hole?
Yeah, in the gully there. He doesn't want to put in a new septic system because sewer will be there within a few years.
You're basically saying there'll be no new construction until the sewer's there
Or pay twice, put in a septic system now and
to use for a couple of years.
for a couple of years, yes.
Right,
So this would be.
we had kicked around this idea of, granting tight tanks, and Tom Lee reached out to DEP and said, hey, this is our situation, this is what we're thinking of doing, and they were like, no, we don't like tight tanks. It's like, okay, well, thanks for your input, but the wording that Tom has kind of come up with, Tom McKeon, is that if we do this, issue a temporary tight tank for properties that either have, like, say, for instance, this gentleman came to us and said, I have a collapsed septic system, it's a hole in my yard, and I got a quote for a brand-new system, it's $15,000, but I'm only 7 years away from sewer, what can I do? This is an idea of granting temporary tight tanks, or someone that has a new home, that wants to build a new home, where sewer's gonna be available in 2 or 3 years, let them put in
What does a tight tank cost?
it's just a solid
I know
tank.
what it is. What does it cost?
Oh, depends on the size of the tank, but anywhere from $5,000 to, $7,000 installed.
And then
You just pump it.
pump it. until
Yeah, I mean,
you can connect to the sewer.
right, and a toilet is what, 1.6 liters per flush? And, we could do the math, but it's, the average home generates about, what, 100 gallons a day? If
Yeah,
it's a 4-bedroom?
yeah.
It's the design, and I understand it's 440, but
right.
in actual reality,
200 maybe?
yeah, and if you know that it's going into a tank that you have to pay to pump, you're more careful, If it's yellow, let it mellow. If it's brown, flush it down.
Now, what I'm asking for is not to require engineering plans. Title V requires engineering plans, and instead Tom Lee offered to help me provide a list, provide alarms, a list of things that are required, and maybe a nice, neat sketch plan would suffice if the board would allow that, to save money on engineering plans for holding tanks.
Sounds pretty reasonable. I mean, I think there are going to be people who are just going to say, I'll hold for 3 years.
Right.
Well,
But if somebody's hell-bent and wants to build something, and they.
Yeah, I mean, you
they're
might.
fine Spending the money.
Yeah, you might be between a rock and a hard place where your building permit is going to expire,
Yeah.
or your, your materials order is, going to be this much if you wait 2 years, or you want to build now, but you don't want to put a brand-new septic system in to only have to demolish it 5 years from now when
Right.
sewer comes down. So we're thinking, adopting a policy where people can come into us and say, can I put in a temporary tight tank? Because the wording would not be a permanent, it would be temporary, it would just be a bridge.
And it will include language saying that when sewer becomes available, you have to connect with.
Yeah,
a
we would
certain length of
always,
time.
we would always
Yeah.
caveat it with what we just did, saying, we'll give you this, but you gotta hook up as soon as it's available.
Right.
You can't dilly-dally on
That
it.
seems very
Sounds
reasonable.
very reasonable.
Yeah.
I think there's something written that requires that in the state law anyways. Like, I remember we did a sewer system in the town of Chelmsford, it had no problem because the regulation was that as soon as the pipe in front of your house was available, you had to hook into it.
Well, that's how it's written now, but the reality is, you can't get a blood from stone, and if it's, someone doesn't have the money to hook up, or if
wow.
they've, like Dr. Miller, many, many, many years ago developed, was like, basically like a pattern, a schedule of, for Stewart's Creek people, is if you had a new system put in within the last 5 years, we'll give you 10 years to hook up. If you had a system put in within the last 7 years, we'll give you 12 years to hook, he created a schedule of allowing people, rather than double whammying people with the cost of a new
was there.
septic. I know you were, so I'm reminding you. And I know that there are other towns that aren't as reasonable, and they say, you will hook up, and if you don't, we're gonna, take you to court, or do it for you and assess it on your property tax. But it's nothing we have to take a vote on, it's just if we're going to enact a policy that, moving forward, we would entertain temporary holding tanks for people that are in that niche. Okay, thank you for that. And then the deadline, we're going to just continue to have this on the agenda because we, don't want to just forget it, but we're going to be proposing policy to deal with the deadline of when to connect to public sewer once it becomes available and the criteria surrounding that.
But I will tell you, I'm getting calls, and I tell people on the phone 6 months in anticipation that this will be adopted, because they are asking, how much time will I have? So, to me, the sooner the better to adopt this policy.
Yeah.
If you
When they
could.
was first started Stewart's Creek, Roger Parsons, you remember Roger Parsons? He became town and,
Turn your microphone on.
oh, it's on.
You're too far away from the mic, Ben.
It's not on.
This one, not that one.
Oh,
Roger Parsons, who became the town engineer. And he did a lot of research into hooking up the sewers. And I believe I'm gonna look and see if I still have some of those papers that gives dates of hookups.
Okay. And then finally, the minutes from January 24th, 2023. Any comments or questions on the minutes?
motion to accept the minutes.
I have a motion to accept the minutes.
Second?
I have a second. All those in favor of accepting the minutes, aye. That concludes our agenda. I would entertain a motion to adjourn.
Motion.
Second. All those in favor? Aye.
Aye.
We are adjourned. Thank you so much.